Morning, everyone. Good morning, Minister.
Good morning, Chair.
Welcome to the third hearing of Portfolio Committee Number 1, Premier and Finance, for the additional round of hearings for the inquiry into budget estimates 2023 and 2024. Firstly, I would like to acknowledge the Gadigal people of the Eora Nation, the traditional custodians of the lands on which we are meeting today. I pay my respects to elders past and present and celebrate the diversity of Aboriginal peoples and their ongoing cultures and connections to the lands and waters of New South Wales. I also acknowledge and pay my respects to any Aboriginal and Torres Strait Islander people joining us today. My name is Jeremy Buckingham and I am the chair of this committee. I welcome Minister Sophie Cotsis and accompanying officials to this hearing. Today, the committee will examine the proposed expenditure for the portfolios of industrial relations, work health and safety. I ask everyone in the room to please turn their mobile phones to silent. Parliamentary privilege applies to witnesses in relation to the evidence they give today. However, it does not apply to what witnesses say outside of the hearing. I urge witnesses to be careful about making comments to the media or to others after completing their evidence. In addition, the Legislative Council has adopted rules to provide procedural fairness for inquiry participants. I encourage committee members and witnesses to be mindful of these procedures. To all the witnesses, welcome. Some of you, welcome again, and thank you for making the time to give evidence. Minister, I remind you that you do not need to be sworn as you've already sworn an oath to your office as a Member of Parliament. I would also like to remind most other witnesses that you do not need to be sworn as you have been sworn at an earlier budget estimates hearing before this committee. Mr. Head, since you have not appeared before this committee during the inquiry, could you please state your full name and title and swear either an oath or affirmation?
Graham Head, Secretary, Department of Customer Service. I solemnly, sincerely and truly declare and affirm that the evidence now about to be given by me shall be the truth, the whole truth and nothing but the truth.
Thank you, Mr. Head. Today's hearing will be conducted from 9:15am to 5:30pm. We are joined by the Minister for the morning session from 9:15am to 1pm, with a 15-minute break at 11am. In the afternoon, we'll hear from departmental witnesses from 2pm to 5:30pm, with a 15-minute break at 3:30pm. During these sessions, there will be questions from the opposition and crossbench members only, and then 15 minutes allocated for government questions at 10:45am, 12:45pm and 5:15pm. We will now begin with questions from the opposition. Mr. Tudor.
Thank you, Minister. In January 2023, Safe Work New South Wales instituted a set of regulatory priorities, did it not?
Regulatory priorities for the year or for...
Did it issue a set of regulatory priorities?
In January 2023?
Yes.
In January 2023, I wasn't the Minister responsible.
Well,
Sorry?
did they issue a set of regulatory priorities? Perhaps you might
I'm happy
assist Mr. Head.
Yeah, I'm happy to refer that to Mr. Head or Mr. Curtin.
Safe Work New South Wales through 2023 has been working to a set of regulatory priorities. I don't have the date as to when they were issued, but I imagine it was early 2023.
Are you aware of the provisions relating to those regulatory priorities, Minister?
Certainly, yeah.
Are they? You are? Well, perhaps you can tell us.
The regulatory priorities.
Yeah, our priorities for 2023 were what?
We were elected in March 2023 with an agenda to reform work health and safety in New South Wales. And you didn't have a work health and safety minister. You didn't have a work health and safety standalone regulator. It was embedded in a regulatory division with fair trading.
Minister, just listen to my question.
No, I'm listening to your question.
There's a document which has been identified by your department that exists, and you've said that you know what those priorities are.
It's an annual regulatory priority.
Good. Thank you.
Yeah, it's an annual regulatory priority.
What are the priorities, Minister?
What do you mean, what are the priorities?
What were the priorities set out in the document?
The priorities are about making sure that PCBUs are compliant with the work health and safety laws, making sure that there's education and awareness about
Perhaps
issues.
you can help the Minister.
Order. Order. Mr. Tudor Hope, it doesn't help the conduct of the hearing if you interject, and the Minister was in the middle of giving an answer to your question. So
There is a set of priorities. Mr. Curtin, perhaps you can assist the Minister on what those priorities were in 2023.
Yes, in 2023, Safe Work determined a set of regulatory priorities for the year. Those 7 priorities were gig economy,
Correct.
safety around moving plant, seasonal workplaces, psychological health and safety,
That's right.
respect at work, exposure to harmful substances, and falls.
Does that assist your memory?
We're doing
Minister.
that work. We're doing that work.
Good. Thank you, Minister.
We're doing that work.
You'll recall that one of the regulatory priorities for 2023 was respect at work. Do you recall that?
Yes, I do. I know. I'm
Recall that?
very
Do you know
aware
what
of that.
how that priority has been expanded on in relation to what the document contains?
The respect at work documentation. So that was a priority that was set by the department, the agency at the time. We have expanded that. Yes, we have
Well,
established
it's not expanded. It's expanded in the document, Minister.
We have established a Respect at Work Advisory Council, which was launched in October of last year.
Going to the document, what does it provide in relation to respect at work?
With respect to your, so can I just want to, is there an issue that you're trying to
Well,
resolve
just-
here?
just-
Because
I'm asking you the question,
the
Minister.
Respect at Work document has been workshopped over a very
If I
long
can assist you,
period of
Minister,
time.
respect at work requires to reduce the incidence of bullying, sexual
That's right.
harassment and customer aggression in the workplace, particularly in male-dominated sectors and healthcare. You
That's
agree
right.
that that's the
that's
priority? which
That's
you
the
have?
document, yeah.
Well,
That's
Minister, if I can ask you this in relation to that, would you agree that in the circumstances relating to Rochelle Hicks, there is certainly serious workplace issues relating to the manner in which she has been treated in her workplace?
Mr. Tudor-Hope and to the committee, I take this very, very seriously, and I, along with my colleague, the Minister for Regional Transport and colleagues, have made a statement of, where this is very terrible, what's happened, and my colleague, the Minister for Regional Transport, has made a statement in the Parliament. Mr. Tudor-Hope and through the chair, everyone deserves to be safe at work. Everyone deserves to be safe at work. Absolutely.
So what action
so
has Safe Work
I'd like-
New South Wales taken in relation to the death threats which were made to Rochelle Hicks?
Firstly, I'd like to express my support, sympathy and apologies to Rochelle Hicks. Sincerely do. Nobody deserves, not Miss Hicks, nobody deserves to feel unsafe, to be threatened, bullied, intimidated in the workplace. Not at all. And I know that we're all on equal footing
Correct.
on that point. And as I said, my colleague made the statement in November 2023. I am advised that Safe Work are making inquiries, and I can't comment further.
Well, Mr.
Mr.
Curtin,
Curtin,
what
did you-
steps have been taken by Safe Work New South Wales?
Yeah, so Safe Work New South Wales had undertaken a search of our database, and no request for service had been received in relation to that matter. As a result of it being raised in Parliament on the 8th of February, Safe Work made further inquiries and has now contacted Transport for New South Wales to undertake those inquiries.
And what's the form of those inquiries?
A standard format for an inspector to make contact with Transport for New South Wales, undertake inquiries, obtain information if required to make an assessment as to the circumstances of the matter.
Will a report be made available in relation to the finalisation of those inquiries?
We'll progress this as we would any other investigation or any other inquiry matter.
Well, have you had any discussions, Minister, with any of your colleagues in relation to the issues raised in respect of Rochelle Hicks? And when did you have those discussions?
Mr. Tudor-Hope, I have been briefed by Minister Aitchison, and with respect to the time, I mean, obviously this issue was raised in the Parliament in November, and as I said, I too express my sympathy and support and apologies that nobody in the workplace deserves to be, by anyone, whether it's a colleague or a stakeholder or anyone, and deserves to be intimidated, bullied or threatened. With respect, so that was when I came into knowing that matter, when it was raised in the Parliament, and I can take that on notice in terms of the date when I was...
well then, just in respect of generally complaint in relation to threatening behaviour, you'd be aware, of course, would you not, of an allegation made by a female corrections worker who made a complaint in relation to a senior corrections officer sending explicit pictures not just to her but to her 12-year-old son. Are you aware of that issue?
Mr. Tudor-Hope, if you're going to... I mean, this is absolutely terrible situation that you've raised with me. I mean, if you've got... It is terrible in terms of what's happening, and I can assure you that in terms of Safe Work New South Wales and in terms of government, we are working very, very hard with respect to the issues that you're raising about bullying and harassment, intimidation. With the matter that you're referring to, has this... What are you asking?
Has it been referred to Safe Work New South Wales?
I can refer...
Yeah, so Safe Work New South Wales in January 2023 received a request for service relating to workplace sexual harassment at corrective services. In August 2023 we issued 6 improvement notices in response to preliminary inquiries. The matter is currently being investigated. So in terms of reducing the incidence of sexual harassment in the workplace, what is occurring in relation to corrective services in relation to the male-dominated corrective services sector? Mr. Curtin? I can answer that if you like. So Safe Work New South Wales has a directorate dedicated to respect at work. That team is working across government with the establishment of the Respect at Work strategy and the Respect at Work Advisory Committee that the Minister and I both attended late last year. There's another meeting of that committee due in the next month or so. Businesses across New South Wales have an obligation under work health and safety laws to create safe workplaces and mitigate hazards in the workplace, including those relating to sexual harassment at work. This is a pervasive issue, and everything needs to be done by employers to make sure they remove any hazards related to sexual harassment in the workplace. Safe Work New South Wales Respect at Work Directorate and Task Force will be working across government and across private industry to raise awareness and to increase compliance with WHS laws.
Thank you, Mr. Curtin. Minister, when will Schedule 1.2 of the Industrial Relations Amendment Act 2023 commence?
With respect to that proclamation, that'll happen when the appointment of the judicial officers happen.
Occurs. So, until that time, which court will be hearing industrial matters?
The Industrial Relations Commission.
No, Minister. Which court will be hearing industrial relations matters?
Well, there's matters that are currently before the District Court with respect to work health and safety. There's matters before the Supreme Court, matters before...
So, you made various observations in relation to the Supreme Court, did you not?
Mr.
In the committee stage of the passing of this bill?
Mr. Tudor-Hope, with respect to the government's agenda, I'm very proud that we have made that we have achieved a number of
I-
commitments and promises that we
Minister,
made
I'm-
to
I'm
the
asking you
people
about
of
the
New South
comments.
Wales.
Thank you. Minister, I'm not quibbling about the terms of the legislation. I'm just asking about this. In the committee stage of the bill, you said this in respect of the Supreme Court, that it imposes a legalistic, slow and costly process on workers, public sector employers and unions that are seeking resolution of basic questions around compliance with awards and proper payment of wages and allegations and unlawful industrial action and the proper operation of contracts with workers. Do you recall saying that?
It's part of the reply.
Yes. No.
It's the
Did you
reply.
recall saying it?
It's the reply. It's part of the reply.
Do you recall saying it?
It's part of the reply.
Good. Do you want to amend or withdraw any part of that statement?
Mr. Tudor-Hope, the New South Wales Labor Party took a policy of industrial relations reform to the people of New South Wales. We have a mandate to reform the Industrial Relations
And I'm not
Commission
quibbling with that,
and
Minister.
industrial...
I'm asking you whether you wish to withdraw any part of that statement, which is a criticism of the Supreme
Mr.
Court.
Tudor-Hope, no, that is not correct. And I have absolute respect for the judiciary, absolute respect. And I am so grateful that we live in a democracy where we have these very important institutions and they have been hard fought for, and having the Industrial Relations Commission and Court be reformed in a modern, fit-for-purpose to ensure that working people have access to workplace justice, and that's what I'm very passionate about.
Have you read the statement of the Chief Justice of the Supreme Court in respect of those comments which you made?
Oh, absolutely, and
do you-
I respect, and I absolutely respect the feedback, and I absolutely respect the feedback from our, highest judicial officer.
Well,
Absolutely.
then when the Chief Justice of the Supreme Court says, with respect to the Minister, there are a number of aspects of this statement relating to the Supreme Court that are not accurate and cannot go uncorrected as a matter of public record, do you wish to correct that record now?
Mr. Tudor-Hope,
This is the Chief
I
Justice.
receive,
Yeah.
I receive, with respect to His Honour, we've taken on the feedback, and there have, I can say that can tell you that it's important to listen and take feedback, and we have. And also, those reflections were based on the experiences of practitioners.
Well,
And
in
so
fact,
as-
the Chief Justice dealt with the experience of practitioners, did it not? Because one of the criticisms you made was that judges didn't, in fact, have the sufficient industrial law background. And in fact, the Chief Justice said this, Minister. It said this: as to the suggestion that the Supreme Court judges often do not have an industrial law background, members of the court, including Justice Michael Walton, formerly the President and a judge of the Industrial Relations Commission of New South Wales, Justice Stephen Rothman AM, who had a leading national practice in industrial relations and employment law, and acting
They're
justice,
excellent.
and
They're
Justice
excellent.
Monica Schmidt,
Excellent.
all justices of the
Excellent.
Supreme Court, which
Excellent.
you criticised, Minister.
Excellent. No,
who
I
is
did
also
not.
a former judge of the
I
Industrial
did
Relations
not.
Commission. Matters involving industrial disputes and any complexity are typically dealt with by these judges, with judgments generally being delivered within 3 or 4 months, or less, after multiple days of hearing. In addition, the practices when still at the bar of many other judges of the Supreme Court, including judges of appeal, extended to industrial relations and employment law. Do you still stand by your criticism of the Supreme Court, Minister?
Mr. Tudor-Hope, I responded to the Chief
You
Justice
attacked
of the
it. You
Supreme
attacked the
Court.
Supreme Court.
The Honourable, I
Order.
responded.
Order, Minister.
and thanked him for his feedback.
Minister. A point of order's been taken. Mr. Namber, on the point of order.
Chair, Mr. Tudor-Hope has asked a question. and interspersed with a few statements along the way as well. I think it'd be courteous to the witness to allow her some time to address the questions and the statements that have been made.
Yes, I uphold the point of order. Mr Tudor-Pope, please allow the Minister
Thank
to
you.
answer your questions without interjecting, and provide courtesy to the witnesses at all times, please.
So,
Minister?
do you agree with me that it is unusual for this, for the Chief Justice of the Supreme Court to issue a statement in relation to a matter like this? And I can tell you the last occasion if you want me to.
Go for your life.
30 years ago.
Oh, wow. I was in high school.
Well, you're a Minister of the Crown. And
I am, and I take my role very seriously.
Well,
and
Minister, today
and
was
we're-
an opportunity to apologise
We're listening.
for the criticism
I
of the
have
Supreme
sent
Court.
correspondence.
Point of order, Chair.
Order. Point of order has been taken. Dr Kane on a point of order.
We've just had a point of order upheld about Mr Tudor-Pope interrupting and not letting the Minister answer, and about being courteous. If he could abide by that ruling, it would be appreciated by the committee.
Yes, Mr Tudor-Pope, for the conduct of the hearing, it would be better if you were not interjecting and demanding responses of the witness. It's hard for us to hear. It doesn't assist the hearing, and it's very difficult for
Thank you,
Hansard.
Chair. Does the Attorney-General share your views in relation to the criticism of the Supreme Court?
Our wonderful Attorney General will be before the committee, and you can
Have you
ask
spoken to him about
about
your criticism of the Supreme Court?
I don't agree. I don't agree, and I reject the premise. I reject the premise. And if you have to reread the whole speech in context. We came in and you completely decimated a 100-year-old institution. And even under Nick Greiner and John Fay, and even before that, Askin, they left the commission alone.
They may have done,
Whereas
Mr.
you
I'm
came
asking you
in,
about your criticism
you
of the
ca-
Supreme
that
Court.
I reject that. I absolutely reject that. I have
So
absolute
the
respect.
Supreme-
You have not read. You're picking bits
So
and
the-
pieces, and you're trying to. You're trying
So
to
is
do
the
a crop
Chief
top
Justice
here,
wrong in
where you're
criticising you, is he?
you're trying to do a bit of clickbait, right? That's what you're doing, clickbait, and that's what you're doing.
I don't
That
know
is
what
what
that
you're
means, but,
doing. Well,
Minister, do you disagree then with the criticism of the Chief Justice, do you?
I am, we live in one of the world's best democracies, and how wonderful are we able to, have views and have these absolutely important institutions, and that is an absolutely important institution. And I have the utmost respect, and the reflections that were made were based on the views of practitioners. And if you read my second reading speech, and you put it all into context, and you will see how important this institution, the Industrial Relations Commission, and how important it is for working people.
Thank you, Minister. Mr Borzak.
Thank you. Welcome, Minister.
Good morning, Mr Borzak.
Clickbait. That's.
Click.
I didn't think we'd get a laugh like that, but anyway, we did. Minister, with respect to your new public sector IR platform, the award covering firefighters, for example, expired on Sunday, although I understand the bargaining hasn't even commenced. Is that true?
The discussions, firstly, I would like to acknowledge the women and the men of fire and rescue and our firefighters. Our firefighters do an extraordinary job on behalf of the government for the people of New South Wales. And we have seen them every single day, every single hour. They're out there doing really, really important work. And I want them to know how much respect that we have for them, and a shout out to the fire station next to my office in Campsie, and I'd like to acknowledge the firefighters there. With respect
I'm
to
sure
what
if you need
your
them, Minister, they'll be there.
with
That's
respect
what you're saying. But
with respect to your question, the award, and may I take you back, their award expired before the election last year. So the former government just, locked the door and left the award expired. So we had to come in and and there was an expired award that we had to deal with, and there was a lot of negotiation and discussion. With respect to, you've gone from finalising that award to the discussions starting about this award, and discussions are underway.
Well, Minister, from what the information I've been given is that the department hasn't even been given bargaining parameters yet. Is that right?
Mr. Borzak, look, I'm not going to provide a running commentary about the ins and outs of the processes of these discussions, but can I say that our processes are very different to those by the former government, where there were no discussions. It was a, slam dunk, here we go, draconian wages cap. And then if you want to negotiate, you have to give up your entitlements, your employee-related costs, your employee-related, you had to provide employee-related savings. And so there was no discussion, whereas we have got a new process, and we're going through that process, and that is refreshing, because it means that the agency and the agency and the union can sit down and thrash out issues and bring issues to the fore. I'm happy to throw over to Ms. Dobbins for any further update.
I'm happy to
When will the government be putting an offer to the firefighters? Let's go right to the heart of it.
So the system that this government has put in place allows for ongoing conversations and bargaining to occur, and we're advised that conversations are happening as most recently as yesterday. But essentially the policy provides for the parties to take a cooperative mutual gains approach, and that is through constant ongoing conversations about productivity improvements, workplace changes, etc., etc. That's happening. The ERC, though, is the final approval forum for bargaining positions, and so any agreement to those positions is Cabinet in confidence. But essentially, they are in the process that this government has set up to have those productive discussions.
So I actually didn't get much out of that answer. You're having an ongoing conversation. I understand the conversation around efficiencies and all that sort of stuff, but are you actually engaged in negotiating with the firefighters on their new terms and conditions?
Not personally, because I'm not the employer, but yes, the agency is.
The agency is?
Yes.
Okay.
That's perhaps a question for Mr. Head.
Do you think, or can you point at when that might finalise that process so that they do have an offer on the table?
That'll be a matter for the parties, but the discussions, I understand, are productive, and I would hope that they come to an agreement in the
Minister,
short
if you come, well, obviously at some stage you will come to an agreement. Would wages be backdated based on when the old arrangements expired?
That's Mr. Borzak, that's a very good question, and to give you an example in and as a matter of public record.
Excuse me, Minister, could you just pull the mic a bit towards you? Yeah.
Oh, sorry.
Sorry, yeah, that's it.
I've got a loud enough voice.
No, you're not loud at all, but my hearing's not very good.
It's all right, we've got audiometric testing now. So, Mr. Borzak, when the award expired, the Firefighters Award expired last year, that was in February 2023, and when the negotiations for that award expired, we did back pay, and so there is a precedent has been set. I don't want to say anything outside of, I don't want to say anything outside of that, but that gives you an indication of what we did for the firefighters with respect to their expired award, where they did receive back pay.
So you can't say what they can reasonably expect based on decisions already made. That's what you're saying?
I mean, I don't want to say something where I don't, based on the precedent that was set with respect to their expired award, where they did receive back pay. I'm sure that as we continue on with the negotiations and the process that we've undertaken, their award expired, I think, last week, and I'm sure that there would be an opportunity for some kind of arrangement, but without having those discussions concluded, I can't say definitely.
Because we wouldn't want to prejudice those discussions by making decisions in the room that are they're still subject of bargaining.
No, I understand that's still subject to bargaining, but, I've got to ask the questions.
Yeah, of course.
This government will probably be more inclined to allow for backdated wage adjustments once you get to an agreement than I would have thought the previous government would be. That's all. That's the reason why I asked the question. And there is some precedent there for it. Minister, in the previous estimates committee from late 2023, you were asked about presumptive legislation protecting firefighters from workplace cancers. As I understand it, the New South Wales firefighters are seeking to add numerous additional cancers to the legislation to ensure coverage equal to firefighters interstate and overseas. Can you advise what the status of this matter is?
Thank you, Deputy Chair. And Mr. Borzak, and to the firefighters and their union who are running a very tough, very strong campaign with respect to presumptive cancers. I know, just as a local member, that I'm receiving many emails, not just from firefighters, but also from community and families. And I know that I have signed correspondence to colleagues opposite from other parties who have also contacted me with respect to advocating on behalf of their community about presumptive cancers. I think that this is a critical issue, and our commitment in the last election was to examine improving benefits for firefighters in relation to PTSD claims, as well as examining impairment payments for firefighters. And we have begun this work, and we will be able to comment very soon. And we're doing the work. We are doing the work, and I have sought advice from iCare, as well as I understand Treasury and CIRA about increasing the number of presumptive cancers, and together with Minister Chandavong and the Treasurer, we will be will be looking at all of that work. That work is currently underway, but we will have more to say shortly.
Can you say when?
I can't give you a definitive date.
Okay, thank you.
Thank you, Mr. Borzak. Thank you, Minister. Ms. Boyd.
Thank you very much, Chair, and good morning, Minister.
Good morning. Good morning, Ms. Boyd.
All of the officials attending today. Can we start by talking about the McDougall independent review of safe work? Can I start by asking, I guess, why, if it was delivered in mid-December, we've only just had it published?
Yeah, that's a very good question, and I appreciate your interest in this matter. I appreciate the interest, and we received the report 15th of December, and we needed to. What I wanted to do was make sure that we go through the report. It's a very good report. I thank His Honour Justice McDougall, KC, for his extraordinary work. He led this inquiry over the last 12 months. As we know, there was a very strong campaign for the former government to announce a review, and Mr. McDougall started that work in, I believe, November, December, or that period of 2023. I appreciate his work. And there was a lot to get through. And also, and for the government, rather than just put out a report, I think it was really important that we go through that report. There were a number of terms of reference, obviously, and there were themes that Mr. McDougall covered, and we wanted to go through, do an analysis, and Mr. McDougall, Justice McDougall, has provided 46 really important recommendations, and I really appreciate the work. And this was a collaboration. There were many witnesses that put forward submissions, stakeholders such as employers, unions, whistleblowers, people who'd been affected, injured workers in particular. And I want to thank him on, he's put together a step-by-step process with respect to dealing with injured workers. And this is the recommendations that we have is the roadmap of building a strong, modern, fit-for-purpose safety regulator. But I think some of the recommendations are critical, particularly about how we deal with injured workers. There's a lot of work to do, and I think that was, and that's why I wanted to do the work.
A good chunk of the terms of reference were outsourced by Mr. McDougall to NOUS, particularly the bits around triaging, culture, the performance and effectiveness of educational functions. I think out of the 4 terms of reference, NOUS were responsible for all of 1, all of 2, and quite a big chunk of 3. Do you think that weakened the report at all? Do you have any concerns about that outsourcing?
Yeah, Miss Boyd, look, the contract and the facilitation of that whole process was undertaken by the former government, and that's a matter for them in terms of how they dealt with, how they came up with that. But I think overall, Mr. McDougall has done an exceptional job, and I want to thank him and his team. It's providing, there's a couple of things here, and we were together with families last week. We were together with our co-chairs of the Family of Injured Workers and support group. And that group was established under the former government, and it was established under very difficult circumstances, where a number of the committee members lost their kids in workplace incidents. And I really appreciate that they came. A number of them live interstate, but they came in, and it was a very, for them, it vindicated what they had been through, gave them a sense of vindication. They had contributed as part of that. They made a contribution to this report, but also it gave not only them, but the thousands of people out there who are seriously injured or injured, they're on workers' compensation, parents who've lost their sons and daughters at workplace accidents. It gives them a sense of, it's not closure. You're never going to close if you've lost a child, but just a sense that the government is on the path, is on that road of fixing the system, and that's what I'm dedicated in doing with our fantastic team.
So I guess,
of Mr. Curtin and Mr. Head.
That's really the focus of the question here, because like you, I've spoken to a lot of families of injured workers and injured workers themselves. Like you, I have spent a long time being exposed to
and
the
I appreciate
stories
your work on this
of
too.
Safe Works.
Thank you.
But when I read this report, it doesn't reflect what I have heard. And so I guess the question that I'm asking you is, do you think that sort of outsourcing to that extra layer of distance from the person writing the report with the people who were giving the evidence has perhaps weakened the stories and the recommendations that we have in this report? Look,
I think that His Honour Justice McDougall did the work, oversaw, and this was part of the contractual arrangements that were made prior to me being sworn in. It was an independent report, so I had to be. I'm very mindful of that
Yeah.
of my duty, and but for me as a minister, receiving this report after many years of all of us advocating that we needed a report, we needed to shine the light on a system that wasn't working. It had broken down for a very long time.
And we're in furious agreement on that. But I personally am disappointed by this report.
And I take your feedback.
Yeah. Can we just look at one aspect in particular then as an example? So the triage system. We have heard of, for example, so this is the system where there's an incident, there's someone has been injured at work, and then Safe Work has to work out what to do with that. They can send an inspector out to find out what happened.
Yeah.
We know that there's been, and it was noted in the report, and particularly, you look at the Auditor General's report into Safe Work when it comes to triaging. We know that, for example, people have had their fingers cut off, and the response from Safe Work has been to send administrative letters rather than to send out an inspector.
Yeah.
We know again from the Auditor General's report that those letters aren't followed up on to see if people have improved the issues that led to that. And yet we have, on the basis of the Nous report back to McDougall, we have basically a statement that Nous concluded Safe Work had established an effective and well-documented triage process. Nothing to see here. Does that accord with what you know to be true about the triage process that Safe Work engages in?
Miss Boyd, and again through the chair, I want to let you and the members of the committee and the public that we have got two sets of recommendations from the Audit Office and from Justice McDougall, and we support those. They will be implemented. It will take time, and I want to assure the people of New South Wales that the New South Wales government under Premier Minns has, first of all, come into government and has a dedicated Minister for Work, Health and Safety, that we will have a standalone regulator, that we will have a strong, fit, modern regulator. And only a few weeks ago, I, along with Mr. Head and Mr. Curtin, who I'm working very, very closely with, and we're working together to implement the recommendations. But also, alongside, as I said a few weeks ago, alongside Mr. Head and Mr. Curtin, we spoke to the leaders and of Safe Work, the leaders, the inspectors, the managers, and we are on a pathway of change. And we are on a pathway of change to be responsive and respectful. And I agree, we have to be responsive.
Can I bring you back to the question I was asking then in relation to whether or not this report accurately captures the problems with the triaging system? When we look at the McDougall report, there's a bit of what I would call actually a bit of a patronising statement in there, saying that basically looking at why the findings in the Nous report are different to what was in the multitude of submissions in relation to that issue. And he says they are based on the reactions of the individual or the organisation to particular events. It's not always the case the individual organisation is able to put the subject matter of the submission into the context of the functioning of Safe Work as an entity, which is effectively fobbing off those experiences. Doesn't that cause you concern with the integrity and quality of this report?
I want to let the people who have had a bad experience, I want them to know that they're vindicated, because I'm listening as the minister and we are taking action, and I want them to know that I'm listening, I'm being respectful to their issues, and for them to feel vindicated that what they are saying is real, and we are going to fix this. We are on the pathway of fixing these issues, and I am very confident in our team, and we're on the pathway forward. We're not going to be able to fix this overnight, but we have to do this, and we're overseeing. Like, for me, this is something that I'm very passionate about, because if we can get employers doing the right thing from the very beginning, then we'll have less seriously injured people. And we're working together with the workers, with the employers, with government, with community organisations. We can get this right. So I appreciate your work in this area, but I want people to know that their issues are real and they're vindicated, and we are on the pathway of reform.
Thank you, Minister. Mr. Rath.
Minister, you previously said that you're in the process of making appointments to the new Industrial Relations Court. Is Mark Gibeon SC a candidate to join the Industrial Relations Court?
Sorry, Mr. Rath, so can you just rephrase, are you asking me a question about something that I've said in here?
You said previously...
Previously, as in today?
As in today, you said
Right.
that the Industrial Relations Court would be established when you had finalised the appointments to that court.
Because we haven't made the proclamation on that part yet.
Yes. So is Mark Gibeon SC a candidate to join the Industrial Relations
Mr. Rath,
Court?
Mr. Rath, there's an expression of interest process. There is an expression of interest process as we speak, and anyone can put forward their applications.
Have you or your office spoken to Mr. Gibeon about joining the Industrial Relations Court?
Are you No. Are you serious?
What about Shane Prince SC? Is he a candidate to join the Industrial Relations Court? Have you spoken to him?
Mr. Rath, I'm not going to provide a running commentary. I'm not going to provide a running commentary. I take this role very, very seriously. These are judicial appointments, and there is a process, and there is an important process. This is an important institution, and I am not going to have a running commentary at all. There is an EOI process, and I understand that is run through the AGs, and I just want to make sure that I don't say anything to prejudice the process, and there is an EOI process.
Do you know Mr. Prince? He sits on the ALP Review Tribunal.
Point of order. A point of order has been taken
It's
by...
really a relevance point in circumstances where the Minister has said that she's not going to provide evidence on who may or may not be applicants. But there's also, I think, a propriety issue in circumstances where appointments to a judicial body or quasi-judicial body are to be made, and to start floating people's names in a gratuitous way when the Minister has said that she won't provide a running commentary where it's perfectly appropriate not to do so, it's really just an attempt to damage people, it would seem.
Yeah, I am... I do uphold the point of order. I'd ask Mr. Rath to desist from naming people, running through a list of people when the Minister has said that she is disinclined, for reasons she's put, to do so, for the reasons she said. So, Mr. Rath?
Well, we are eagerly awaiting the appointments,
Well then,
Minister.
can I just ask this, Minister, would you rule out that the Industrial Court will not be stacked with Labor lawyers?
Oh, you're fine to talk your side.
Order.
The last 3 appointments.
It's just an attempt to get around the ruling that you just made.
I'm not naming particular
Well, it
people.
is. There's been a naming of a person, a naming of their association.
I just did order. I did rule, and I'll remind Mr. Tudor of that ruling.
Well-
The Minister has made a contribution that she's not going to explore that area, so I'd ask Mr. Rath to continue his line of questioning.
Minister, moving back to the previously commentary on the Supreme Court and indeed the High Court, are you aware of the High Court decision in Kirk 2010 relating to the former Industrial Relations Court? And I quote from them that legislation which would take from a state Supreme Court power to grant relief on account of jurisdictional error is beyond state legislative power. Are you aware of that from the High Court in 2010?
I am.
You are?
Well,
So,
well, Minister, in light of that, did you want to revise some of the previous statements that you'd made on the Supreme Court? And why is the industrial court immune to judicial review?
that's not correct. So, the amendments that re-establish the industrial court do not and cannot prevent the Court of Appeal hearing and determining a summons seeking a judicial review of decisions of the Industrial Relations Commission or the Industrial Court. Any attempt to do so would be futile, and the High Court has ruled on this in the past, and we are certainly not attempting to circumvent this.
Well, Minister, why did you draft in the legislation that the industrial court is immune from judicial review? So are you correct, or is the High Court correct?
No. I go back to what I've just stated, that there is that I refer you to my previous response.
Well, are you confident then that the privative clause, section 179 in the legislation, where appeals to the Supreme Court for all matters other than industrial manslaughter, are you confident that that would not be subject to a constitutional challenge?
Well, I've just said to you that that's not, I refer you to my previous response with respect to the amendments that re-establish the industrial court do not and cannot prevent the Court of Appeal hearing and determining a summons seeking a judicial review of decisions of the Industrial Relations Commission. So,
Well, I understand that, Minister, but then why put in the legislation that there is no right to appeal from a ruling from the industrial court? Why would you put that in the legislation?
what do you mean?
Why did you draft it in that way?
Point of order.
Well,
A point of order has been taken, Mr. Nanva.
The Minister may well choose to answer this question, but the Legislative Council practice, whilst making it clear that House procedure doesn't strictly apply, it can guide proceedings. I would only note that standing orders make it clear that questions shouldn't be asked around seeking of legal opinions, which is clearly what is happening at the moment.
To the point of order.
We'll just
Yeah,
wait.
so I just asked that the Legislative Council practice at least guide these proceedings.
Well, to the point of order, I'm asking a question about recently passed legislation in this place. I'm not asking for a legal opinion. I'm asking about the legislation that the ministers should be well aware of and how it was drafted and the potential for constitutional challenges. I'm not asking for a legal opinion. I'm not asking about a matter that's currently before a court.
Thank you, Mr. Ruff. Yeah, well, I won't uphold the point of order, but mindful of the contribution of Mr. Nanva that we should not be seeking a legal opinion. So I'll allow the
we
questions.
can ask for Lawrence. I'll give you one.
I'm just really tempted to intervene, but I won't.
It is probably unconstitutional, but it's okay.
Well, Minister, are you confident that the legislation that has been drafted and that has passed this place, that it would not be subject to a constitutional challenge? Have you received that advice?
I've responded to you, Mr. Rath. I've responded to you.
But why put it in the legislation at all? Or if you're saying that matters can be appealed to the Supreme Court or the High Court, why not remove that part from the legislation? Can you commit to an amendment to the legislation you recently passed to remove that provision in the bill?
We went through that process, Mr. Rath, and I refer you to my previous answer.
Well, then it's been drawn to your attention.
You go, Phil.
I want to take you back to some questions which were asked to by the Deputy Chair in relation to the engagement with the Fire Brigade Employees Union. You recall that there was a demonstration outside the Parliament last week, or the week before, by the union?
Certainly I do. It was.
Did you go out and speak to them?
It was this week.
Did you go out and speak to them?
What do you mean?
Did you go and speak to them to give them some assurance in relation to the demands they were making? Yeah. Did you go out and speak to the members of the union?
But
Yes or no?
I was in meetings doing
Yes.
my work.
So you didn't. So, yeah, Minister, can you tell us whether an engagement council process has been set up in respect of the engagement with?
Mr. Tudorhope,
The irony.
we're in discussions. Like we are in discussions, and
Well,
we are in discussions, and we're doing something that your government didn't do for 12 years. Like we're fixing this. You were the minister for employee relations. You went to the election without fixing their award. You left them with an expired award.
no, thank you. And
You did.
When did the current award expire?
The current award expired a few days ago.
24th of February. So you've also, in fact, left them
We're
with
in
an expired award,
discussions.
have you,
We're
Minister?
in discussions.
Well-
Like
well-
we're in discussions.
And so are
We're having very productive,
Good. So,
very
but
collaborative
Minister,
discussions.
there's an important point here in relation to this, and
and I do take you seriously because
well,
as a lawyer, I know that you care about these.
So you didn't
these
come to an
matters.
agreement before the 25th of 25th of February 2024. No,
An-
clearly.
an
There's no
agreement.
agreement. There's no agreement been reached with the union before that date, has there?
They're in discussions.
They're in discussions. So the legislation provides for an engagement council, does it not?
It's a great idea.
Well,
It's a
Well-
top idea.
yeah. So
Something you
So,
guys should
in
have done.
relation to the engagement council, is that process being entered into with the union?
They're currently engaging with each other.
Yeah,
So
well, who's-
the agency and the FBU are currently engaging.
Well, who's part of that engagement council?
They're talking. They're in
Yeah, well,
discussions. The agency and the union.
Well, we've got names of the people who are engaged in the engagement council.
But they're talking. Are you talking about a formal process of engagement?
Yes.
The formal process of engagement councils, that's going to happen. I mean, the legislation came in November, and we were left with this massive mess from your government. And we're going through these issues step by step. And the engagement councils are a very good idea. And in terms of when they're going to be formally established, the agencies, the many agencies, and you know this, the many agencies in
Minister,
government
I know what I know.
already
Yes,
have
clearly.
joint. They already have joint groups in many of the larger agencies. You know, there are joint engage.
So your interpretation of the expression engagement council is just we're talking. Is that your interpretation?
No, we haven't.
So
Let
is
me
there
make
a
this clear.
formal-
We are in the process of formally establishing engagement councils,
So
but
you're in
at
the process of-
at the moment, because the firefighters award has,
Okay, so I understand,
has
you're in the process of establishing a body called the Engagement Council, are you?
each agency.
Yep.
Each agency has the opportunity to be part of an engagement council.
And in relation to this, I think the evidence you just gave was that you're in the process of, in fact, engaging in setting up those engagement councils, are you?
With respect to the firefighters,
Yes.
or just in generally?
No,
in
just
general?
with respect to the firefighters.
The firefighters are currently speaking. They're currently in discussions. But in terms of having the firefighters engagement council as we speak, no. But they are in discussions, and we will have a formal process in establishing engagement councils. I think that if you whatever you're trying to do, like, trick me or stunt.
I'm not
you know,
trying to
pull a
trick you, Madam,
stunt.
I'd just like to get some
But
clear answers.
no, I'll give you an example. The engagement council should not be seen in light of it's just about the wages and conditions. The engagement council and even under your government, and I'll give you a tiny bit of credit. even under your government, you
You've
did,
adopted most of our
you
document,
did, you did have, even under your government, you did have in a number of agencies that did have a sort of a joint groups with union, with agency directors or managers working through important issues. And that happened. That's important in terms of engaging about various issues. I mean,
Very similar to a document we have prepared. But let me tell you, you have a document which in fact is the New South Wales Fair Pay and Bargaining Policy 2023. You're aware of that document, are you?
I am.
You're across the detail of it.
I am.
Good. Well, we'll see.
Here we go. You're going to test me.
Well, I'm just going to ask you about some key positions in relation to it, and you will see.
But did you, with respect to the, in all seriousness, the engagement council process is a formal engagement council between the agency and the union, not just for the period upcoming to an award negotiation. It's a constant. It's a continuous council where issues are put on the agenda, and they are resolved before it goes any further. Whether it's disputation, we want to be able to troubleshoot issues before they escalate, and I think that's a logical step. I'm sure you would think it's a logical step.
So why haven't you signed off on any bargaining parameters? Can you tell me?
What do you mean?
Well, why haven't you signed off on any bargaining parameters?
That's a cabinet process. It's a matter for the.
The terms of the bargaining parameters are a matter for ERC and cabinet to consider. But why haven't you signed off on them?
It's a matter for the cabinet.
No, it's a matter for you, Minister. Because the bargaining parameters require Treasury and your approval. Have you signed off on bargaining parameters?
Guess what, Mr. Tudor-Hope? You've got the Treasury here tomorrow.
No,
I'm sure you're going to have lots of fun with him tomorrow.
I will.
And you can also ask him.
But why haven't you signed off, Minister? Don't avoid it by.
I'm not avoiding.
Tell me why you haven't signed off on it,
Mr. Tudor-Hope. As you know, there are processes, and we're going through. And this is a cabinet process.
Minister. A requirement of the bargaining process is for the establishment of bargaining parameters. Is there a reason why you have not signed off on bargaining parameters for this union?
Mr. Tudor-Hope, have you had why do you care about these issues? You didn't care for 12 years. You didn't bargain with these unions for 12 years. No, it's quite hypocritical for you to try and trip me over.
Very direct question.
No, you're trying to trip me over here, and what you're trying to do is, we can all see it. You didn't do anything for 12 years. You know, can I say a case? There will be a doctorate about the way that your government arranged this wages cap.
Minister, can I ask you again?
There will be a doctorate in. There is a doctorate in this.
Can I ask you again, Minister? And this is a very direct question.
And I've
why
answered.
have you not?
Mr. Tudor-Hope,
signed off on bargaining
I
parameters?
have responded to you, and there are processes, and you know that, and I refer you to my previous response.
So the agreement expires, and you have no bargaining parameters in place.
There are discussions.
Isn't that insulting to this union?
We're doing a lot more.
Isn't this insulting?
With a straight face, that's impressive.
We're doing a lot more. We are doing a lot more than you ever did in the 12 years. We are doing a lot more. We gave them the highest pay rise.
Is that the view?
And we provided.
Is that the view of Leighton Drury? Is that the view of Leighton Drury?
The secretary of this union is
What's his
advocating very strongly on behalf of his members.
So when he says the lack of bargaining parameters is the main obstacle to progress, and you haven't even signed off on. Well, how on earth do you expect to come to an agreement?
you know what? You're going to get asked next time to go and speak at their rally.
I'd be delighted to, because
Okay, I'll hold you to it.
I'd be
I'll
delighted
hold
to.
you to it.
So, if you are going to engage in good faith bargaining,
hold you to
if
it.
you're going to engage in good faith bargaining, Minister, wouldn't you in fact at least go to the table, at least the discussions with bargaining parameters?
We are in very productive discussions.
Would you have you got bargaining parameters, Minister?
I'll refer you to my previous
of order.
answer.
Minister,
Point of order has been taken. Dr. Kane, or you both.
Mr Tudor Hope has repeatedly asked the same question to the Minister, and she's offered an answer and referred him to a previous question. It's verging on the point of badgering the Minister.
To the point of order, it is true that the Minister can answer any way that she would like, despite the non-responses, but it is also true that we can ask the questions how we would like to ask them, and I think that it is entirely appropriate to try and get more detail about this important issue of bargaining parameters.
To the point of order, Chair.
Dr. Kane.
Agree with Mr Rath about the need to ask questions and the appropriateness of it. It's the manner in which it's done that I'm taking issue with. Mr Tudor Hope is getting increasingly excited, and that's coming across as disrespectful to the Minister.
Yeah,
so I
we
asked
should have
Mr Tudor Hope to moderate his excitement in the next series of questions.
Look,
They're going to let him drive. They're going to let him drive a
to
truck.
remain unexcited. The Minister can
I
respond.
talk to them at my place, and
That
my-
might
my-
not necessarily
my
be the
station's just
answer
down
that
the
Mr
road
Tudor
from
Hope
me.
wants.
I go and
but
see them often.
We
They
definitely
love
need
I
to
bet you they
remain
love you.
respectful of times. Order. Your time has expired.
I'm going to nominate you
Mr.
for a
Borzak.
membership.
Thank you, Chair.
I'm going to get you a membership.
Save us from it.
They'd be happy to have.
I dare you to wear the T-shirt.
Minister,
Sorry.
I'll bring you back to the question at hand. I want to go back to presumptive legislation on workplace cancers and ask you what has your portfolio specifically done to progress the matter since the last estimates hearings last year?
Thank you, Mr. Borzak. And as you raised this very important issue earlier, and I know that you really care about this issue, and you did raise this matter at the last hearing in November. And I have, as I said, we have done some very important work, and we're continuing to do that work. And I'm happy to refer to Mr. Harding because we have been doing some analysis on that, haven't we, Mr. Harding?
Thank you, Minister. Yes. So, Mr. Borzak, we've provided various costings and actuarial estimates for a number of different presumptive events, the cancers and as well as the PTSD presumptive issues that the government has raised. We've had conversations with Treasury in respect to those. Unfortunately, it's really in the hands of CIRA. CIRA is the determining body for the legislation, and so we've provided advice to the Minister, and that's been passed on to through the relevant channels to Minister Chandavong and to CIRA. So we've done the work to estimate the costings.
What you're saying, Mr. Harding, is the ball's back in the Minister's court. Is that right?
As Mr. Harding indicated, that the work, the analysis is underway, has been done, and we're working with Minister Chandavong and Treasury. So, as I said, we'll have more to say about that. But I just want everyone to know, and I know that there are firefighters listening to this, and this is very important because they do critical work. They're out there on the front line. They are very important specialists in what they do, experts, and our community is safer because of them and the work that they do. And we, as a government, have an obligation. All of us, in fact, have an obligation to protect those that put their lives on the line, and our firefighters put their lives on the line.
Minister, thank you.
I want to assure them that they are top of mind, they are top of our work in terms of priority, and we will have more to say.
Do you have any concern about this research? Is that what's delaying it?
There's no we will go through our internal processes, and as I said, that Minister Chandavong and the Treasurer and myself are working through. So we will have more to say very shortly.
All right, thank you. So there's no specific hurdles. It's process driven. Is that what you're saying?
It's process driven, but we want to get this right. This is very, very important, and we want to get it right.
Okay, thank you. Mr. Issues of bullying and harassment within the volunteer agencies such as the RFS have recently featured again in the media. You have spent some time with the portfolio now. How comfortable are you with volunteer agencies are across their health and safety duties to volunteer and paid employees alike?
Mr. Borzak, volunteer organisations such as the RFS have work health and safety duties under New South Wales work health and safety laws, and they are obligated to follow those rules. Now, workplace sexual harassment is a work health and safety risk, and all PCBUs, including the RFS, are required to assess and address this risk. All volunteers at the RFS who carry out work for a volunteer organisation are also considered workers who are protected under the New South Wales work health and safety laws. So volunteers who carry out work for a volunteer organisation, that is a PCBU, also have health and safety obligations at work, and this includes taking reasonable care of the health and safety of themselves and others. So it's my expectation that Safe Work New South Wales, and I'm happy to also defer to Mr. Curtin, they do all it can to prevent sexual harassment, not only at the RFS but all workplaces. Mr. Curtin, would you like to add to that?
Minister, I think you've covered it very well actually, but the WHS requirements are really clear about volunteer organisations that have paid staff have the same obligations in terms of compliance with WHS laws. Safe Work New South Wales has, in the period of 1 January 2022 to the present time, received one request for a matter in relation to sexual harassment at the RFS in specific reference to that agency. Volunteer agencies, like all other agencies, are required to meet the requirements of work health and safety laws. I can refer back to some content in relation to the Respect at Work Directorate and the work that Safe Work New South Wales is currently doing to make sure that all employers are aware of their obligations and that employees are behaving in ways that are consistent with the laws, and that we're doing everything.
I might just, because I'm going to run out of time, but I might just interject there and say, Minister, who are, in your view, the worst performing agencies in this space?
With respect to sexual...
Well, in respect to anything
harassment.
in relation to bullying and harassment claims.
Yeah. Mr. Borzak, look, I have a real concern with respect to a number of agencies that, through the public sector employee survey, and this trend has been growing and increasing upward, and we do have a real problem, and it's something that we not just looking at. This is something that we're very conscious about, and that we're doing work. I'm happy to also ask Mr. Head. I know that there's some work that is being undertaken across government about bullying and harassment in the workplace.
Thanks, Minister. That is my understanding. The Public Service Commission generally leads work guiding the sector on bullying and harassment, and that's been the case since even as far back as when I was Commissioner and introduced the employee survey back in 2012. Agency heads, of course, are responsible for taking action in respect of their own findings, but in fact Mr. Draper, as the head of the Premier's Department, may wish to comment more on the whole of government initiatives.
Yeah, look, I think it's just really well established now that bullying is one of the main workplace health and safety risks, and also just a conduct risk, and it's specifically addressed in codes of conduct. It's very clearly, all the leaders in organisations go through training in that regard. And the PMES has for many years recorded not only the incidence of bullying, but also the rate at which people report bullying, which is also very important. And so one of the things that...
Mr Draper, you've been around long enough to know, and so have I, that Rural Fire Service seems to keep coming up and keep coming up and keep coming up, especially in relation to the interaction of paid employees and volunteers. I've sat through and chaired numerous inquiries in years past, specifically into those frontline bullying allegations, and the RFS has featured extensively. And yet here we are talking about it again. What actually are we going to do?
Yeah, look, I haven't... sometimes these things do get referred to the Premier's Department or the Public Service Commission. I haven't had the Rural Fire Service referred to me. There are organisations whose, in the PMS results, exhibit higher rates of reported bullying, observed bullying. Sometimes they're quite small organisations, and so they stand out. But I couldn't comment on the RFS, I'm afraid.
Okay, thank you.
Ms Boyd.
Thank you very much, Chair. Just coming back then to this McDougall report into safe work, another area that appears to have the sort of what's in the report doesn't really seem to go far enough, as far as I'm concerned, in relation to what I've heard on bullying and cultural issues within safe work. Given that, you know, obviously safe work is responsible for ensuring that we have minimal psychosocial hazards within various workplaces, and we've all been very concerned about the uptick in claims in relation to psychological harm and psychosocial harm. Do you think, Minister, that the psychosocial hazards within safe work itself have been adequately addressed in this report?
Thank you for that question. And in terms of the organisational structure of Safe Work New South Wales and internal matters, it's I'll refer it to Mr. Curtin, because I know that Mr. Curtin is undertaking major change based on the issues that you've raised, but also, more importantly, the McDougall and now the Audit Office recommendations. So I'll refer you to Mr. Curtin.
Thank you.
Yeah, the McDougall report and the analysis done by NOUS analysed complaints handling processes and grievance processes, and that's available for anyone to read and understand. In terms of expectations for Safe Work New South Wales, I've set a very clear expectation for the leadership team and everyone in Safe Work New South Wales that we should be an exemplar employer when it comes to work health and safety, when it comes to psychosocial risk. Under the new arrangements and new structural arrangements, we'll be working forward to make sure we've got the right conditions to make sure that everyone in Safe Work New South Wales can come to work and make a meaningful contribution in a safe and healthy environment.
So that's really my primary concern here, because obviously complaints handling is after the event, whereas what we want Safe Work to be doing in other places is to intervene to stop harm beginning in the first place. What is Safe Work doing to take that seriously and change the culture that leads to the harm in the first place?
Just before Mr. Curtin answers, Ms. Boyd, if I may, since taking over as Secretary, Mr. Curtin and I have been working very closely together on all of the issues associated with the transformation of Safe Work, including those that the government's responded to in the McDougall report. A key part of those discussions has been about the internal culture and how to set up a kind of constructive approach to managing change and managing the issues and frustrations that people have been experiencing. And I think the Minister alluded in one of her earlier answers to a question to an initial whole of leadership discussion that occurred a couple of weeks ago, and a big focus of that discussion is in fact about having our own house in order, and that includes the well-being of staff and also the behaviours that we expect of everyone, including leaders in the organisation. Mr. Curtin's working in a detailed way with his team on those things, but that's, we see, one of the critical enablers of the next stage for establishing the new Safe Work.
Dealing with any problem, there's the obviously there's a few steps to take place, but the first one is to recognise that there is a problem.
Yep.
Do you think that the report really encapsulates the size of the problem when it comes to safe works culture?
Well, the report traverses a range of issues. Not really for me to mark the report. It raises many important issues. Some of those issues are also issues raised in the Auditor General's report. So there are consistent themes, I think, but also the People Matter employee survey that's been referred to a couple of times this morning is also a very valuable input to what's really happening, the size of the problem in the organisation, but also where we might reasonably see some uplift in people's experience based on where we direct our effort. So I think what you're wanting to understand here is, do we accept that there's a problem and that resolving that problem is a key part of taking the next step? I think the answer to that is yes.
Thank you. Minister, one of the other things I understand was in a number of submissions that I don't think has made it into the report is in relation to the underpayment of allowances to safe work inspectors. Are you aware of this issue?
I do have... I am aware, but I'm happy to either refer to Mr. Curtin or Ms. Dobbins.
I understand.
If we don't have that, we can get it for you.
Maybe I can ask Mr. Curtin. There was, I understand it, a series of non-payments of single-day meal claims.
Yeah.
And recently that's resulted in back payment to inspectors of up to $3,000. I understand that's not an isolated incident, but also SafeWork's been denying payment of protective clothing allowance to inspectors. Is that correct?
It's not my awareness that there's any outstanding concerns at the moment. I understand there was an issue last year that's been resolved and worked through. If there are any outstanding matters in terms of underpayments, they haven't come to my attention.
Okay.
Just on that. So I do recall there was an outstanding issue around the meal allowances. I do recall that. We can get you additional information. The issues that you've just raised now, that's new, and I haven't heard about that. So we will, whether in the break or after this, make further inquiries. But I want to assure inspectors and those who do really important work in the organisation. We want to ensure that the award is fulfilled, but if there's anything outstanding, that we will look at that. So I want to reassure our inspectors and our employees in Safe Work New South Wales, and in fact the public service.
Thank you. Ms McDougall referred to a draft of the report being sent to SafeWork, and SafeWork requesting some changes. One of them was in relation to what type of standalone organisation SafeWork should become, which I might come to in a bit. But were there any other recommendations that SafeWork asked to be changed?
We had the opportunity to respond to Mr. McDougall's draft report. We provided a range of feedback that he broadly incorporated into the report itself. There's a range of commentary through the report that indicates where SafeWork had provided some information back to Mr. McDougall.
So why did that recommendation change then in relation to whether or not, I understand it's whether or not it would be a statutory corporation or something more akin to the EPA? Why did you make that recommendation?
I can answer that. The construction in the original report was not merely a statutory corporation, it was a state-owned corporation. So effectively, the model that was put forward was a model that's consistent with the model that's used for government businesses, not usually used for regulatory entities. We simply pointed that out, that a statutory corporation that was exercising regulatory powers wouldn't typically be constructed in the model of a state-owned corporation, and that there were other examples of statutory entities with their own enabling acts that were more typically, that would be more typically used for regulatory entities.
Yeah, I have to say I do agree, having gone through the Tahi experience. I do agree with you on that. Minister, I think this is my final question in relation to this report. There is some concern from the stakeholders I've spoken to that on the back of this we will set up Safe Work as a standalone regulator and then that will be the end of the story. Can you give some assurance that you understand that obviously culture and everything else doesn't get changed but just by changing the type of entity we're looking at, and that will just be one part of a much larger suite of changes?
Yeah, I want to assure the people of New South Wales and also the, when we say the stakeholders, injured workers, the workers, employers, organisations, people who have worked for Safe Work New South Wales in its various forms. And I want to assure everyone that we are working very diligently and in a methodical and a considered way. We want to establish a standalone regulator that is going to endure all governments, ours, whoever comes next, and in all its machinations of, minority governments or what have you. We are all on one page, and we should all be on one page, that everyone, every single worker deserves to go to their job and come home safely to their loved ones. It's simple as that. That statement is, it's not, Labor, Liberal, Greens, Teals, whatever. This is, I meet people, I meet families who've lost their 18-year-old, 19-year-old kids on work sites. We need to get this right, and I want to assure that as Minister, this is a critical portfolio for us and for myself and for the government. We have an excellent team and we're working together, and I want to assure that there will be oversight. There will be oversight, and there will be an opportunity for that openness and accountability and making sure that we're getting things right. It's not going to happen. It's not going to happen overnight. But having read the Auditor General's report, and as shocking as it is, we're on that pathway. We've got the roadmap. We've also got the response to the Law and Justice Committee. The response is coming out next week. The government response is coming out next week. There is a lot of work for us to do, but I think this is not just across government, but across party. We've got to look at this in a practical way, but also being responsive. And I think that the having this kind of regulatory enmeshed entanglement of regulatory bodies hasn't worked. I understand that there was probably a rationale, a philosophy, but it hasn't worked because it's meant that we haven't been able to disclose and be transparent about incidents or about how we make decisions. And I think that the Audit Office, in its critique about openness and accountability, I think it's giving us an opportunity to say we're going to establish a standalone regulator, get all the operations right. We're going to have employers and employees together, working together, but also having an oversight process where your committee can be able to ask questions like you do with iCare and CIRA. Thank you.
Thank you, Minister. The opposition.
So you've told us, Minister, previously that you're in furious negotiations with the unions, and they have been very productive. You recall giving that evidence, don't you?
Yes.
You're engaging with them.
Yes.
And you'd be aware that your own document in relation to negotiations say that all those discussions are without prejudice until such time as you've got bargaining parameters in place. Minister, I ask you again, why have you not got bargaining parameters in place for dealing in relation to the claims by the FBEU?
Mr. Tudor-Hope, I refer you to my previous answer, and we are currently going through those processes. And
after the award has expired,
we've
while
been going through those processes.
So why do you turn up to these meetings with the union? Why do you turn up in circumstances where you've got no parameters in relation to which you can reach an agreement? What's the point?
Is that a statement, or is
No,
that
I'm
like I'm
asking
going to let you
Minister.
go on your soapbox?
I'm asking you. I'm asking.
We've got work. We are going through. We inherited. I know you keep hearing this, and I know you hate it. Okay, and listen, I sat in opposition for 12 years. It really
Minister,
is awful. Okay,
don't tell me about what I did. Tell me what you're
doing. You know
doing.
what? No, because what you did affects what we're doing now.
What,
this is the thing. In 2011,
I would never go to a negotiation without bargaining parameters.
in 2011, we're in 2011. We raised some practical points to the then government, the O'Farrell government, about what this would mean, what the wages cap would mean.
But you've got to know when you go to have discussions with the union what you can concede and what you can't, Minister. Isn't that the case?
But we're running a different system to what you ran. We're running you.
This is the system. Minister.
You imposed.
This is the system. This is the system.
You imposed
Your
a
document.
wages. It is our document, but you imposed a wages cap that. Well, happy to.
Well, I think that's concluded that little section there. We now turn to questions from the government or not. Or not. No, so we don't have questions from the government, so that means we will have a break and we will reconvene at 11:15. Thank you very much. We'll see you all then for more excitement. opposition. Thank you everyone for returning. I will now recommence with 20 minutes of questions from the opposition.
Minister, just a couple more questions on the bargaining proposals. Do you agree that it's your role to sign off on the bargaining proposals?
It's a...
Under your policy, it's your role to sign off on those proposals?
Yeah. So can I... And I've
yes.
thought about... I've thought about what you... I hear what you're... I do understand why you're asking me, and I have thought about this during the break. The way that you're thinking about bringing forward bargaining parameters for the whole sector, where yourself and others would go in, get the bargaining parameters, and it was a positional process. This isn't a positional process. The process that this government is establishing is one of good faith mutual gains bargaining. So you're bringing forward. So you're having discussions. I hear and look. I'm going to try. As much as I want to, I'm not going to be political. I understand this. The document that you have in front of you. Yes, it does have a series of steps for the agencies. Now, I'm not the agent.
You've got to sign off on it, don't you? Isn't that the process?
I've got to sign off
on the bargaining proposal. You have to sign.
But each agency. That's but it's a number of us that have that responsibility. But I don't think you.
And the treasurer. And the portfolio minister.
The portfolio minister. But in terms of going back to your concerns about this matter and the process, is that I'm not the employer. We're not the employer. It's the agency that is negotiating with the union, and the whole process has changed. It's not a positional one where you come in, like a traditional bargaining. One side comes in with a log of claims, the other side comes in, you're knocking heads, but even under your system, even though you're saying, okay, you took bargaining parameters, right, but at the end of the day, you still couldn't negotiate to get a better pay rise than the 2.5 because it was
Minister, let's not do this. But
no, I'm not.
I understand what the point that you're making.
No, but I understand. I understand what you're like. I have thought about this. What you said.
But do you have to?
And I don't think you're getting that the process has changed. So it's not a one size fits all.
But to actually reach an agreement, you have to have. There is a process for having a proposal approved, and you're a signatory to that proposal, are you not?
In terms of the individual award,
yes.
The award.
There's a bargaining proposal, and your own document provides for it.
Yeah, there's a process. That's right. But
so the portfolio minister, has he in fact provided you with any details relating to that proposal?
The portfolio minister.
You're
Minister talking about the firefighters.
Yeah, the minister did provided you with any.
Mr. Tudor-Hope, the agency. So fire and rescue.
Has he given you any draft bargaining proposals?
So, Mr. Tudor-Hope, fire and rescue are working through these matters with the union.
Has he provided you with any? Has he provided you with any draft proposals?
Look, he was here yesterday.
Has he provided you? Has he provided you?
But I'm not the employer.
Has he provided you?
But I'm not the employer.
Point of order's been taken. Point of order, Mr. Namber.
Chair, wide degree of latitude has been given to this line of questioning. My point of order just goes to relevance. The Minister has made it clear that the agency minister is the person who this question would be better directed to, and I would suggest that's where this question should be directed.
To the point of order, it is entirely relevant to the portfolio of the Industrial Relations Minister, who has responsibility for these bargaining proposals.
Further to the point of order.
To the point of order. Namber?
The questioning is specifically related to the development of a bargaining proposal by an agency. I would still suggest that that is better directed to the agency minister.
The wide latitude is given in these hearings to, a broad range of questions, so I won't uphold the point of order, but remind Mr Tudor-Hope to treat our witnesses with courtesy at all time and allow them to answer.
We're very
rather
good
than
friends,
to and
this
fro.
Minister and I, so I would never treat her discourteously. But Minister, I just want to put, has Minister Dibb provided you with any bargaining proposals?
So, the agency and the union are in discussions, and the agency.
So the answer is no. Is the answer no?
No, but
Is the answer no, that he hasn't provided you with draft bargaining proposals?
I'm aware that the agency. I am very aware, very aware of the of what the FBU are putting forward in terms of their what they would like, what their expectation is, what their members expect. But there are currently discussions underway with the agency. So the agency, this is how it's working now, where the agency and the union are sitting down and working through these issues. It's not positional. Yes. When there is a in terms of the discussions are being had.
Well, aren't you going to take something to ERC at some stage?
Of course there's a process that has to be undertaken, of course.
And you are a party to that process?
But absolutely.
And you have received nothing as part of that process from Minister Dibb,
Mr Tudor-Hope, but we're going. Let me take you to 5 steps back. We're not just, we're not doing what you did, where you did allow awards to expire for months on end, and then you would turn up, and then you would. Discussions are being had. Now, when you took when you went through your process, it would take months and months and months, and the frustration. I mean, look at what happened with rail. Look at what happened with some of the earlier awards. Now, I know that you had
Ms Dobbins and I have history in relation.
Ms Dobbins has PTSD.
Sorry, I won't mention. Sorry, actually,
I dream about Alex.
Actually, Mr. Nanva. Sorry, Mr. Nanva.
Anyway,
Order. I could feel, this diagonal line across. I apologise to Miss Dobbins and Mr. Nanva and Mr. Tudor-Hope for that.
Perhaps,
look, discussions are happening.
I think we're all at one.
Minister, I wanted to go back to the Industrial Relations Court, and in particular on the appointments. I wanted to quote to you the Financial Review from the other day. The Financial Review understands Ms Cotsis drew up a preliminary list last year that included Mr Chin. Mr Gibeon and Mr Prince have also been sounded out. Can you confirm or reject that rumour that has been published in the Financial Review 6 days ago?
That's Mr Rath. I take my responsibility in this portfolio very, very seriously. The government made an announcement that we took industrial relations platform to the election. We've got a mandate. We're establishing the court. There is a process. There's an EOI process, and I take my role very, very seriously. There is an EOI process, and I urge people from across Australia who are interested.
Is the AFR right that you were sounding people out?
No, absolutely not.
Well, that's how they were wrong. No, that was the question.
No. You just said sounding out. That's not. That's
what the Financial Review said.
report.
It said Mr Gibeon and Mr Prince have also been sounded out.
So you reject, that's not true?
That I take this responsibility. No, I take this responsibility very seriously. Like this is an independent court. There's a process, and we're bringing. I mean, I'm very, very proud that we are bringing in work health and safety and other matters into this court, and there is a process at hand.
But I think given the rumours in the financial review, I did want to give you the opportunity today to reject those assertions.
I've responded to you. I've responded to you.
Can I just take you back, Minister? You may recall on the last occasion I asked you some questions in relation to DLOs in your office. You recall me those questions I asked you? In fact, I think you confirmed that one of them, in fact, had previously worked for me when I was the relevant minister. Do you recall the questions, and you confirmed that no representations had been made to the department in respect of the appointment of DLOs in your office? Is that not correct?
Sorry, let me just... So if you can... Yeah, you asked me the question, yeah.
So you asked... And you said that no representation had been made in relation to the appointment of DLOs in your office.
You have to go back to the transcript and get the exact wording. Because I know where you're going. I do know where you're going.
Oh.
And so you need to go back to the transcript and you need to ask the exact question, and I've given you the exact...
So what you're saying is that you, in respect to the question I asked, the answer was true. Well, then let me frame it in a different way. Was any representation made by you or your office seeking the appointment of a DLO in your office?
So this is my understanding, okay, that my office had made early inquiries about DLOs and the appointment process.
And your office, just in relation to that, who is James Hamilton?
He's my excellent Chief of Staff.
Good. So, did he make inquiries in relation to a potential candidate?
Mr. Tudorhope, my office had made early inquiries about DLOs, because this was a new office, and we made early inquiries about the process.
It wasn't about the process, Minister. It was a specific candidate.
No, that is not correct. We had asked for the process, and there's a request. There was 2 shortlisted candidates, and we wanted to know the process, and we took the advice of the department. So we followed the process.
Well, is that your interpretation of the recollection of members of the department?
What do you mean?
Well, if a member of the department had actually rang you, did they not? About representations which had been made to by Mr. Hamilton.
And that was, as I indicated to you, there were 2 shortlisted candidates. There was an internal process that the department undertook. There was their process, and we took their advice.
Well, and the Minister, the department in fact rang you while you were at an event, did they not, to advise you in relation to the inappropriateness of the process being encouraged by Mr. Hamilton?
No, there was no... I reject that. I do. I reject that, and I reject that because we took the advice, as you do. We took the
because
advice...
Because you wanted a particular person to be appointed, and they, in fact, had to give you advice, did they not, in relation to the inappropriate
There were
nature
two
of
shortlisted.
the request?
There were two shortlisted candidates, and there was a process that was undertaken, an internal process undertaken, and there were shortlisted candidates, and it went through a process, and we took the advice of the department. We took the advice of the department, and in fact, and as I said to you last time, that we do have one of the DLOs that was in your office, and we took the advice of the department, and we. I seek advice on a range of matters.
But she gave you advice about the inappropriateness of seeking to engage this particular person and the manner
There
in which
was
it
a
was
short
being done.
list, Mr. Tudor Hope. I think you'd have to reread.
I'm reading it.
There's a short list. There was a short list, and we wanted to. We asked for advice.
How do they
and
sit-
we sought the advice, and we got the advice, and we followed the advice, and we followed the process, and we got the advice.
Minister, the fact is, you were given independent advice, were you not? And the departmental officer rang you directly because they were concerned that the process being adopted by your office was contrary to, and in fact Mr Head has intimate knowledge in relation to these issues, contrary to directions relating to ministerial intervention or involvement in relation to departmental approvals. Did she not ring you in relation to that issue?
I recall that there was a conversation, but it was we took the advice.
Yeah, well,
we took the advice.
Well, how do I interpret this, Minister? The note made by the relevant person said this: I told her the DLO was a departmental appointment, not a ministerial one, and there were real risks for her as a minister and us as the department if she were to interfere with the process.
Point of order.
A point of order has been taken. Mr Namber on a point of order.
Chair, if Mr Tudor Hope is relying on a document for his line of questioning, could we ask that he table a document?
Well, I don't have to table. I'm putting to her a proposal.
I can't compel Mr Tudor Hope to table it, but he is
While
at liberty, so there's no point of order.
While
Mr.
previously there might have been a bit of grey around it, since the Barilaro incident, we have been told in no uncertain terms that there can be no political ministerial interference in departmental appointments. How on earth would you interpret that paragraph if, other than a suggestion that the ministerial office was seeking to interfere with a departmental appointment?
No, I reject that. We took the advice. We took the advice of the departmental officer.
Of course you took their advice after that conversation.
No, we took... Hang on a minute. You have to put it into context. And we took the advice. There was an internal process that was undertaken by the department. We sought advice, and we got the advice, and we took the advice.
Well, in respect of the person who gave you that advice, what position are they in now?
The departmental officer.
Yes.
I'm not sure. I believe that. Sorry. They're in the Department of Customer Service.
They were responsible for Safe at Work New South Wales at the time?
At the time, that's
They're
correct.
no longer in that position?
That's correct.
Were you responsible in any way for that change?
Sorry?
Were you responsible for a change in that person's role?
Sorry.
Was it your idea that they be moved?
Absolutely no. The respectful professional that you're talking about is an absolute professional who I deal with at the moment with respect to another agency that I have responsibility for.
Well, I'll just conclude by saying this, putting this to you, Minister. The public servant that you had the dealing with in relation to your officer's intervention in relation to a DLO, that person thought it was so serious that they would make a detailed file note in relation to it. Does this not show that there were real concerns within the department about interference by your office in a departmental matter?
I take the advice of our departmental officials very, very seriously, and at no stage and by no means my office or myself did anything other than to listen to the advice, and we seek advice on a whole range of matters, and I have the utmost respect for the official that you have mentioned, because of the excellent workings in terms of the pathway to a number of my agencies, and I have absolute respect. And
thank you, Minister. Minister, some questions from myself. Minister, from the outset, I'd like to say that I'd like to thank you personally on behalf of a lot of tradespeople for the work you and your agencies and the government's done on the move to ban crystalline silica or engineered stone products in this country. And I'd particularly like to thank iCare for the care that they've shown me, and the impact that's had on me and my family. That said, some questions, Minister. On the 14th of December, it was announced that the various Work Health and Safety Ministers and Work Health Australia had agreed on a framework and for the ban on engineered stone with more than 1% by weight of crystalline silica, and that, and I quote, arrangements for working legacy products such as removal, modification, repair and disposal will be managed by jurisdictions based on a national framework developed by Safe Work Australia, due to be provided to ministers by the February 2024. Has that framework been provided to ministers? Minister.
Thank you, Mr. Buckingham, and thank you for your very strong advocacy on the ban of engineered stone, and I know that you played a critical role yourself, and many stonemasons and construction workers played a pivotal role in making sure that we banned engineered stone. With respect to the questions that you've asked, as you know, the Minns government strongly supports the ban on the use of engineered stone. We promised in opposition that we would take the strongest possible action to protect workers against the scourge of silicosis. We did meet the ministers, the federal minister and ministers met last year to prohibit the use, supply and manufacture of engineered stone. This prohibition will commence in New South Wales 1st of July. Now, the ministers also agreed that we need for a transition period for contracts entered into or on behalf or before 13th of December. Details are expected to be settled by ministers at the next meeting, which is in March, so it's in a few weeks' time. Now, we've also agreed to appropriate exceptions for certain activities. The Work Health and Safety Ministers have agreed to appropriate exceptions for certain activities such as removal, repair, minor modification and disposal of legacy products installed prior to the prohibition. Businesses and consumers are encouraged to be mindful of the upcoming prohibition and avoid entering contracts that may not be fulfilled. I acknowledge the impact the ban will have on many businesses across the country, especially businesses whose only product is engineered stone. And my office and I will continue to meet with affected businesses and continue to do so while the transition to the ban of engineered stone continues. It's important that businesses, especially small ones, are not left behind by the impending ban, and that we will be talking with the other ministers and the Commonwealth in a couple of weeks' time about more of the details.
Thank you, Minister. So will this require enabling legislation, or can this be done in terms of New South Wales by regulation, the implementation of this prohibition?
Yes, there will be a requirement Yes.
for legislation.
Yeah.
In terms of the issue that I touched on and you've just referred to there, the legacy issues,
Yeah.
you've said that, and the announcement said that there will be a requirement post July 1 that removal, repair and disposal will be conducted by a qualified tradesperson. Who is a qualified tradesperson to remove, repair or dispose of this engineered stone?
Those discussions are currently underway in terms of those details with our officials and the Commonwealth officials. I'm happy to refer you to Mr. Curtin, who I know is playing a pivotal leading role, particularly with his background as a firefighter. But also I understand that similar to, and I'm not going to, I have to be mindful, similar to asbestos removal, where you have, specialist qualified workers.
So just on that, Minister, that's exactly where I was going. Will there be a requirement that this qualified tradesperson is licensed by the relevant agency to do that?
Yeah, it's a very good point, because what we're seeing at the moment and my concern, post July 1, it's happening now, where you have your DIY and so I'll refer you to Mr. Curtin.
Yeah, thank you. Those discussions are underway, and the mechanisms as to how that will be managed is still being discussed between various states and territories in the Commonwealth, and that will go to the meeting of ministers on the 15th of March to be resolved. It's important to recognise that the risk comes from the creation of dust, including silica, and it's those conditions that we're looking to control as best as possible.
But that's a relatively short period, like we're talking 4 months till July the 1st, and as of July the 1st, it'll be legislated that this has to be removed, repaired or disposed of by a qualified tradesperson, but we don't have anyone qualified to do that or licensed to do that at this stage, do we?
Yeah, the mechanisms how that work are still under discussion. It might be that there's a form of registration or licensing system. It may be that it might be a notification system through to Safe Work New South Wales. We still need to work through those details to make sure we get the balance right, making sure we keep safe working conditions, but allow those works to be undertaken in safe ways.
What does the notification process mean? What do you mean by that?
It may be that people undertaking those types of works need to make a notification to Safe Work New South Wales when they're undertaking those works, so that if we want to undertake compliance activities, we can do that because we've got the notification system in place.
That may be the case.
How
are we going to tell the construction industry and DIYers what effort are we going to make, if any, to notify the community that this ban's in place and that there's now in place a new regime of prohibition and potentially requirements for licensing and notification, etc.?
Yeah, all of that will need to be worked through. It's important we take a nationally consistent approach so that we've got the same conditions across the country. The ministers have been really clear about making sure we keep a nationally consistent approach. So the Commonwealth is drawing up a communication strategy that will help us to communicate all of those elements to the community and to the industries.
Is there a risk, Minister, that with the ban coming in, that that some businesses may take it upon themselves to remove this material or do these works before there's this new regime in place, where potentially you have qualified tradespeople licensed, notifying and undertaking a particular procedure, wet cutting, dust suppression, these types of things?
Sorry, my concern...
Well, is there a risk that the ban's coming in, there's going to be a requirement for the qualified tradespeople removing it, that some people will remove this material, repair this material before that occurs?
Yeah. It's so there's a couple of points to this. So I want to thank and acknowledge the industry groups, and aside from of course the advocacy of yourself and others, and Miss Boyd and others around here that have been very strong advocates, and our Labor members here, and I know that Mr. Tudor Hope made some representations when he was in government. There is a process, Mike, and I want to thank the industry groups and some of the small businesses that have already started doing a lot of work in terms of the stock that they have, and many of them took it upon themselves to deal with those matters and change to alternative products. With respect to the workers, that is a very big concern. Of course, all the control measures that are currently in the law have to be abided by, but that is a very big concern, and this is why we're working towards the details leading up to the Work Health and Safety Ministers meeting, and get a consistency across the nation.
Thank you. Miss Boyd.
Thank you very much, Chair. Ahead of the election, New South Wales Labor made a commitment to examine legislating presumption in workers' compensation claims for PTSD for firefighters. Where is that up to?
We're fulfilling our commitment, and currently. So as I mentioned earlier, that our commitment in the last election was to examine improving benefits for firefighters in relation to PTSD claims, as well as examining impairment payments for firefighters.
Mm-hmm.
We have begun the work, and we'll be able to comment shortly about
Thank
that.
you.
But we made a commitment, and we're currently going through that work. But it's a very serious matter with respect to PTSD claims and impairment payments, but we're currently doing that work.
Thank you. Queensland, since 2021, has had presumptive PTSD for all of their frontline workers who have exposure, either directly or indirectly, to traumatic incidents. Will you be, when you come to examine that legislation, will you be proposing a much broader PTSD presumption?
I don't have that detail, but I think it's important for us, as we're currently undertaking and examining the work, looking at what other states are doing as well. We obviously have, we're currently undertaking that work and looking at other jurisdictions as well, and look at what's working and what's not.
You would agree, though, that the re-traumatising of any worker having to prove PTSD, particularly the current system, it's not just adversarial, it's also asking people to name the day on which they experienced that trauma. That
needs
has to change.
I'm saying that needs to change. It absolutely needs to change. You know, our frontline essential servicemen and women do an incredible job, especially in emergency services and all our services. And we're seeing, more and more. We ask as a community, we're asking our services to do a lot. And when they go out there and, see, I'm not going to, whether it's human remains or whether, like, the work that they're undertaking is very traumatic. And I know from recent tragic events, where we not only as a society, not only as a government, but a society, have to look after people that are doing this important work. And you're absolutely right. It's something that we are undertaking the work. We did make a commitment, and we'll have more to say about that. But yeah, you're absolutely right. And the system shouldn't be adversarial. And this is what we're looking at in terms of, other areas as well, where we need to change the system around to be less adversarial and more about, what concerns me is you have injured workers, whether it's psychosocial or PTSD, where they're being re-traumatised again and again because they're having to retell the story to 3 or 4 different agencies. And we're working really hard, and all of us. So, I know Mr. Harding, Mr. Draper, Mr. Head, Mr. Curtin, we're Miss Campbell in Treasury, all of us, Miss Dobbins, all of us actually, the agencies that you see here, we are all working across government in how we can have where our essential workers tell their story once, and this is also part of our whole of government return to work strategy. But as you see us all here, we're all part of the agencies here are doing some really important work, and we'll have more to say, but we're happy to consult with all of you about this.
Thank you. Is there a timeline for when we might see legislation on presumptive PTSD?
I don't have a timeline, but I will advocate very strongly for for that legislation as soon as we can.
Thank you. Another bit of legislative change that people have been contacting my office about is in relation to the lump sum death benefit. So this was something that was part of the State Insurance and Care Legislation Amendment Bill that the former Minister Dominello had put forward in 2022, basically allowing people, instead of it being an all or nothing, allowing some sort of compromise on lump sum death benefits. Is that something that your government will be introducing?
It's been raised with us, and that was, I can't recall why it got, but I do recall that because there were a number of really important provisions, and but happy to take that on notice, but I'm happy to look at that.
Because I understand that all came out of the McDougall eye care review.
Eye care,
and you're right, the bill got shelved. I can't remember why either, but you have implemented a number of these things already, but that one
it
is
would have
still
been
outstanding.
21, 22. Look, I do recall that we were, this did end up getting stuck up there. I'm not sure, Mr.
That's
Harding.
a question for Sarah tomorrow, Minister.
Yeah. Do you,
I
Mr.
can't
Harding?
recall why the bill was pulled either.
You
I think there was a number
remember
of other matters that were associated with that bill. I think there were cause for it to be pulled rather than this.
There were. Look, I don't want to take up your time, but there were a number of other provisions with respect to young people who lost a parent. That was part of that as well. But you're absolutely right about this getting stuck. So we'll do some work about that and find out where that's all up to.
That would be really good.
Yeah.
I think people are concerned. We have yet another McDougall report with a bunch of recommendations. We're still looking at the iCare McDougall report, and some of those recommendations have not yet made their way through for whatever reason. It was pulled under the last government. Can I ask you, just in the time I've got left, here's a bit of a curly one for you. I understand that the New South Wales IRC, you can't email an unfair dismissal application to them. You can only post or take it in person, which seems incredibly antiquated and not in line with what we see in other judicial contexts. Any idea why? Is that something you can look into?
I can assure the users of the system that it is something that has been brought to my attention, even in opposition.
Right.
And we will do everything we can to rectify this and get into the 21st century. Because I've heard of stories where practitioners have to travel, for 2 hours to go to the registry. Yeah. So I want Ms. Dobbins. Do we have any updated advice?
No, but I'm happy to take it on notice and speak to Communities and Justice about that matter, because I agree it's been raised before.
It seems minor on the face of it, but it's causing significant issues for people. So, yeah, that would be great if you could take that one on. I note just recently that SafeWork has a new focus on solar panel retail and installation and the safety and the risk of injury in that process. Are you able to give us a bit of background on sort of how that came about and why that focus is there now?
I'll just to give you, I want to acknowledge that the Electoral Trades Union brought some issues to my attention about safety, and I know that SafeWork has been doing some work, and I appreciate the work that they're doing. So, Mr. Curtin, do you want to advise Ms. Boyd?
Yeah, we've been doing a bit of work around rooftop solar installation projects since October 2021. We've been focusing those inspections around falls and electrical risks. Most recently, we ran a campaign from February through to August, which will run through to August this year, focusing on retailers and installers of solar panels. It's really important. Falls is one of the number one challenges we have in the construction industry. We want to make sure that people are safe when they're undertaking installation of solar panels, and also the electrical issues as well.
Thank you. I'll cede my 10 seconds. Chair?
Thank you.
Wait, 10 seconds, go for it.
Thank you, Minister. In relation to your fair pay and bargaining policy document, do you have a copy in front of you? Do you have a copy?
Fair pay and bargaining
Policy document?
not in front of me, but I can get a copy.
Well,
Do you have a copy, Mr. Tudor?
I have one copy,
That's
which
all
I
right.
need.
Yeah, I've got it.
We do. We're all at one.
All good?
Can I take you to page 2 of that document?
Yep.
And you go to enhancements to remuneration as the heading of the policy which has been adopted by the government. So, for instruments, 3.1 provides a certain parameters, does it not?
3.1.
Yeah.
So for instruments which expire prior to the 30th... Yep.
Prior to the 30th June 24, immediately following the expiry of the current industrial agreement, agencies may offer an annual increase to employment comprising of, and then what is the annual increase which you're allowed to offer?
Right.
That's a 4% increase and a 0.5% for superannuation. Is that right?
Yeah.
So that's the cap that, in terms of the bargaining position of the government in relation to remuneration, is it not?
Is it the quantum?
Yeah, it's the cap that you apply to remuneration.
This is financial year 23-24.
Yes.
So as you're aware, and that we made an offer last year of 4.5%.
Yeah, but this is in relation to all agreements. All agreements.
This is, so we made, as you know, we put forward a proposal of 4.5% for a year.
So all agreements, you've applied a cap of 4% and 0.5% for superannuation. Isn't that the case?
It's not a cap.
It's not a cap.
Well, hang on. It's your remunerations policy, and then it goes on in 3.2%. You'd need approval, would you not, to go outside of that, because it says in respect of additional enhancement, if you go down to clause 3.5, additional enhancements to remuneration or other conditions of employment may also be provided where the associated cost is offset by savings.
Right.
Where have you heard that sort of policy before? Wasn't that the position of that was the position of the previous government in relation to additional wage remuneration, was it not, over and above the cap which had been applied by the previous government?
Right.
So you've applied a cap, haven't you not?
No, it's not. No, it's not a cap.
This is your bargaining document for the purposes of
But you're not reading it in
fair
context.
pay and bargaining policy.
But you're not reading it in context.
Well,
The wages cap has been removed, and in the Industrial Relations Act, the new amendments.
But I'm
you will
talking
see
in
that
terms
there
of what agencies may offer. Agencies are bound by this policy, are they not? So what they are, in fact, notwithstanding that that the parties can then go and explore opportunities in the Industrial Relations Commission, who take into account other matters which are contained in the Act, but for the purposes of establishing in the agency's position in relation to bargaining, this is the policy, is it not?
But it's not a cap.
Well, what is it? It's the policy of the government in relation to wage remuneration, is it not?
Mr. Draper, did you
Maybe-
want to,
maybe
because
it's
you're
a-
the head of the
Yeah.
public service.
Well,
so-
notwithstanding Mr. Draper has a view in relation to this, what is you should know this, Minister, that this is the cap that you apply.
I
No,
guess
it's
the
not a
only-
cap. It's not a cap. We've removed a
Just a
wages
ceiling.
cap.
The only point I was
It's
going
not a
to make,
cap.
the only point I was going to make, Mr. Cherdhope, is that this because we did draft this policy, as you can imagine, that section refers only to 2023-24.
Yep.
So it was introduced. This policy was introduced in December last year, partway through 23-24. The rest of the policy refers to future years, and that provision to the 4.5% doesn't apply to those future years.
Well, it may be reviewed, and I
That
can
was the only
see
point I was
I can
gonna
see that, Mr. Draper, that the nature of as of course by regulation, the previous government could have reviewed the provisions relating to wage increases pursuant to regulations. Isn't that correct?
Yes, correct.
That is correct.
Thank you. How many agreements have been approved since the introduction of this agreement in December last year?
So we were looking at TAFE.
I can answer that if you'd like,
Yeah.
Minister. I don't have the number of agreements that have been approved. I know agreements covering over 230,000 employees have been approved. I can tell you how many agreements have not yet been approved.
Well, I'm interested in that as well. How many have not been approved?
So 14 instruments have yet to be finalised.
And how many, and can you take on notice how many actually have been approved since?
Yes, I can absolutely take that on notice. And of the 14 instruments yet to be finalised, 11 of those are either at an in-principle agreement stage or they're awaiting IRC or Fair Work Commission approval.
How many of those agreements, in fact, have provision for wage remuneration above the 4%?
I'll need to take that on notice.
Any of them?
You'll be aware that the teachers' agreement and
Correct.
the paramedics agreement,
paramedics.
off the top of my head, yes.
Correct. So, Minister, did you have any role to play in relation to the $500 million paramedics pay deal, which was agreed on the 13th of December 2023?
I'm pleased to report that the government's pay offer for paramedics was accepted by the union, and on the 21st of December a new award for paramedics was made by consent before the IRC. The new New South Wales Ambulance Paramedic State Award provides a much needed uplift in paramedic pay following 12 years of wage suppression by the former government, which left our paramedics the lowest paid in the country. The 3-year award, effective from 1 July, provides an increase to salaries and salary-related allowances. And the new award follows the government's ongoing consultation and negotiations with the union and provides record pay increase for our paramedic workforce. Now, the new award, and this is the important point, and this is what the paramedics, under your former government, it delivers professional recognition and remuneration to reflect the move towards university qualifications of paramedics and registration requirements with the Australian Health Practitioner Regulation Agency. It creates a new salary structure.
We've heard, so that wasn't my question. Can I just ask you this? What role did you play in relation to that negotiation?
I'm the IR
Were you involved in
minister.
any of the negotiations?
I'm the IR minister. I'm involved in negotiation.
And you had to sign off on the proposal, did you?
What's your point? We've got.
Did you have to sign off on the proposal?
There's an award. An award's been made. It's gone to the commission. There's consent. There's an award now. The paramedics are the highest paid, and their university qualifications have been recognised. And they're doing incredible work. They're delivering. They deliver professional. So what we've done is deliver a professional salary framework, and creates an expanded salary range for new paramedicine practice, which is what came in 2018 under your government. I mean, but this is the problem.
But you're the minister now.
I'm the minister, and
so
I'm responsible
I'm
for
asking you-
the industrial relations framework, and
one of the things that you're obliged to take into account, of course, is in relation to the bargaining proposals, is giving weight to the government's commitment to a balanced budget, is it not?
Look, absolutely.
That's the framework that your own Act provides for.
Absolutely, that's right. That's
So
the
how
that's
much
the
of this
fiscal.
additional-
We've added that into. We have added the fiscal outlook in the new amendments to the
Correct.
IR. Yeah,
Correct.
we
so
have.
when you're taking
And-
that
and
into account, what component of this wages deal requires a drawdown on the $3.6 billion essential services
Mr.
fund?
Tudor-Hope,
Do you know that, or do you not know that?
You can ask the treasurer, and I'll refer you to
Do you know?
You can ask the treasurer.
Do you know?
Point of order,
You can
Chair.
ask the treasurer tomorrow.
Point of order's been taken. Dr. Kane.
I'd ask that Mr. Tudor-Hope give the Minister enough time to answer. Again, it's a repetition of questions that she is attempting to answer, and I'd ask that he let her finish.
Yes, we must treat I uphold the point of order. We must treat the witnesses with courtesy all the time, and you must give the Minister the opportunity to answer your
Courteously,
very
I
good
put it to you.
questions, Mr. Tudor-Hope.
Courteously, I put this to you. Do you know?
Mr. Tudor-Hope.
No.
Mr. Tudor-Hope, you can ask the treasurer tomorrow, but
So you don't know.
I assure
You don't know.
you, I assure
You
you,
don't know.
and I assure committee members, and I assure the people of New South Wales that we took a policy of removing the wages cap and recognising the value of our public sector workers. We have vacancies in health and in education and in community services and in police because we can't get people to work in the services because of your wages policy.
Well, that's
we
just
have
not true, but anyway.
it is true. It is
Well,
true. We have 1,200 vacancies in police. We have a 7% high turnover of caseworkers. We can't get caseworkers to work. And you have read, and I know that you care about this area of, where we have families who need support from caseworkers, and we have the longest they stay is 18 months. We have a high turnover. I care about this issue, and we need to get it right.
But
And
I'm
the
just
pay of the
interested in your
paramedics,
role.
the paramedics,
interested in your
the men
role
and women
in signing
of
off
our
on it.
ambulance service do an extraordinary job, and we've seen that the work that
point of
they
order,
have done
I'd
over
just
the
like to
last
redirect
couple
the
of
Minister
months,
to answer.
Sorry,
particularly.
Minister, a point of order's been taken.
I'd just like
I
to
must
redirect you, Minister.
A point of order, Mr. Tudor-Hope. What is the point
Well,
of
a
order?
direct relevance.
Mr. Tudor-Hope,
Well,
I-
Mr. Tudor-Hope, if you're going to take a point of order,
It's direct relevance. This is not relevant to
To
the
the
question.
point of
well,
order.
no, I'll rule on the point of order. There's no requirement for the minister to be directly relevant.
There is.
There's no.
There is a
we can be
standing order of
there-
the
there's a-
Legislative
we can go-
Council to be directly relevant.
The questions that we're guided by that practice.
Yes.
We're guided by that
Well,
practice. There's not a requirement for that to operate in these committee hearings.
Well, I redirect-
Order, Mr. Tudor-Hope, I'm ruling, and the minister was being relevant to the question. So I'd ask you to allow her
So I
to
redirect.
answer the question and hear my ruling before you continue on. Mr. Tudor-Hope.
Thank you. So I redirect, Minister, this. How many agreements have you signed off on as Industrial Relations Minister?
Well,
Sorry,
I'm
let
happy
me-
to take. I'm happy to take that on notice,
Right.
but I want to get back to the paramedics.
No, I don't want
The
to.
no,
just
you
answer my
guys know
question.
they in 2018 they got professional standards.
not asked this question. I'll redirect you,
No,
yes.
but
I'll
you
just
but you
redirect.
want to argue with me. We're
I am
fixing
just
up
putting
your
this
mess.
proposal to
We're
you,
fixing
ma'am. I
up
know you're
12
flustered
years.
because you don't know the answers to my questions, and quite frankly,
point of order.
you're
Okay.
having
Point of
to
order.
filibuster like this as a demonstration of that. But
Mr.
in any
Tudor
event,
Hope, order.
filibustered against
Mr.
your
Lawrence on a
wages
point of
cap
order.
2011.
The point of order
know you
relates
did.
to the discourteous stream of insults coming from Mr. Tudor Hope directly.
can we just answer the questions?
Order. Yes, Mr. Tudor Hope. Reflecting on the witness is not helpful, and it is discourteous.
But to-
So avoid that at all costs, please. And for the benefit of everyone else tuning in, for the Secretariat and the Hansard, please desist from interjecting over the top and attempting to redirect the Minister.
Well, I should be able
Mr.
to redirect the Minister.
This is just
Mr.
Not
Tudor Hope, I'm happy to get.
because I did not ask that question, so that's why I'm redirecting her.
With
So,
respect
so,
to
so
the,
Minister,
the
just
agreements
so
that I've
Minister,
signed
just
off
in
on-
relation to that, I have short time. In relation to bargaining parameters, how many have you signed off on?
with respect to
Bargaining proposals.
with bargaining proposals.
How many have you signed off on?
Mr. Tudor Hope. Mr.
You
Tudor
take it
Hope.
on notice if you
I
want
can
it.
take
Point of
it on
order.
notice.
She already
Good,
has
thank
taken it on notice.
Mr. Tudor Hope, I can.
Point of order.
Mr.
Point of
Tudor
order.
Hope, we've had a
Mr.
number
Tudor
of
Hope, order,
agreements.
Mr.
Sorry,
Tudor Hope,
sorry, Chief.
please do not just continue to fire questions and statements at the Minister. I'm finding it very difficult to follow this interaction. So please allow the Minister to answer.
So with respect to the number of agreements,
Yep.
as you know, we have made an agreement with the teachers, with the paramedics. With
Do you know the number?
I'm happy to get you the
Thank you.
number.
Thank you. No,
We're
I'm
working.
happy
I'm
about
happy
it.
to take.
Thank
I'll
you.
take that on
Thank you.
notice. If that makes you happy, you want a number.
We want him to be
If it's going to be more than the agreements you signed off on, if
Thank
it's a
you, thank you.
competition, great.
Minister, Minister, one thing that has emerged from this hearing today is that the detail is particularly lacking, and that's if you need to take it on notice, I'm very happy for you to go and get advice in relation to it. So, Minister, you've established as part of your new framework a peak engagement council comprising representatives in industrial relations, unions, New South Wales, and Treasury. Has that been established yet? That peak
We're currently
council?
going through the process of the Peak Engagement Council, which is what we put
it's
forward
contained
in the
it-
legislation, which is very different.
So
to
when
you.
when will it be finalised?
When it's fine, we're currently doing
So
the
will
work.
the
It's underway.
will the participants
it's
be
a-
paid? Will they receive remuneration for their participation in that council?
It's not in the It's not in the.
There's no. So
it's not
could
in
I
the-
could I understand
It's
that
it's a council, like an advisory council.
Good, thank you.
So when you had there was you in government had a committee, but you never used it.
Can I just ask you this?
It's a committee.
There is provision for training in relation to the opportunities for negotiations, is there not, that you have established?
An opportunity for
training?
Yeah. Yes.
If you go to 4.2.5, industrial relations, Premier's Department will issue guidance and facilitate access to mutual gains bargaining training. Who will provide that training?
Why? Like, we're doing training, but it's...
Who is providing the training, Minister?
I'm happy to take that. Or Ms Dobbins, if you want to...
An organisation called COSOL.
So how much is being paid for the use of their services?
We can take that.
I may be able to get that information and answer this afternoon.
I will. I'll take that up with you this afternoon. And then it says specified training may be mandatory for government sector bargaining representatives. Is it going to be mandatory, that training?
What do you mean? They're government agencies.
This is your policy document,
they're government
Minister.
No, they're government agencies, and we need to
Specified
make
training
sure...
may be mandatory for government sector bargaining representatives.
And we're encouraging agencies to undertake training.
Is it
so
going to
they
be
can
mandatory for any government sector agencies?
Well, I'm happy to
So at the moment, we're encouraging agencies to participate and union parties to participate, but it's not mandatory at the moment. It's early days, so we'll see how that training rolls out.
Minister, have you received Treasury's operational review of iCare?
Not yet.
Not yet. Well, considering that in relation to your media release, you talked about the review and an expected time frame to be available by the 1st of March 2024. Will it be available by tomorrow?
I'm happy to ask Ms Campbell to respond to that.
Thank you, Minister. No, it won't be available tomorrow, Mr Tudor-Hope. It's a complex piece of work and we are targeting April to provide our advice to the Minister.
So it's now, can you give me a date in April that you...
I don't have a precise date, Mr Tudor-Hope.
So would Ms Campbell, while I have you then, will the report identify how you're going to propose to achieve 5% permanent reduction in iCare's net cost of service?
So there are two pieces of work, Mr Tudor-Hope. There is the review that Treasury is doing, and in parallel, the savings plan is the responsibility of the iCare board as to how they will implement the 5% reduction permanently across iCare's costs.
So, Minister, has the iCare board provided you with a board-endorsed savings plan?
I'll take that on notice.
You don't know?
I think the answer is no. That is being done in parallel with the Treasury review, Mr Tudor-Hope.
Thank you. You'll recall in previous occasions that the Treasurer described transfers into the Treasury managed fund as bailouts and attributed the need for these bailouts as a mismanagement of iCare. In your view now, as the responsible minister, is iCare mismanaging the TMF?
Mr Tudor-Hope, the Treasurer, who does have responsibility for the TMF, will be here tomorrow, and you can ask him detailed questions with respect to the TMF. I'm happy to refer you to Mr Harding or Miss Campbell.
Well,
thank you, Mr.
You're happy for me to
fire
ask
away.
that question?
Yeah.
Well, Ms Campbell, in relation to the forward estimates, is there any indication that there will be no requirements for contributions to the TMF?
So it's too early to be able to say, Mr Tudor-Hope. We'll be making that determination closer to the end of this financial year.
Well, you might have a look at page 25 of the half-yearly review, because at page 25 of the half-yearly review, it certainly would not indicate that we would get anywhere near...
All right, order. Mr Tudor-Hope, I'll take that as a statement. That doesn't sound like a question. Minister, you no doubt would be aware of the alcohol and other drugs in the workplace policy that's produced by WorkCover. The Coalition might want to get Barnaby one of these, but that guide provides a framework for employers to provide a workplace that is safe and as risk-free as possible. The guide aims to help employers identify, and I quote, processes for identifying hazards, assessing risks and elimination or control of risks. In addition, the guide says that employers must ensure the health and welfare of all employees by providing, for example, a safe workplace environment free of risks and health. Would the Minister agree that a workplace environment free of risks to health is one that we should all be working to create?
Sure.
Sure, excellent. The guide also contains a warning to employers about drug testing. It states that, and I quote, drug testing as a means of managing alcohol and other drug-related risks has a number of significant limitations. A positive test for alcohol and other drugs is not in itself evidence of impairment of ability to perform or intoxication. This is particularly so in relation to the presence of a drug other than alcohol, where there is much less international consensus on the relationship between the measured level of a drug or its metabolite and levels of impairment. Minister, do you agree with WorkCover that drug testing, as it operates in New South Wales, has a number of significant limitations?
So, can I refer you to Mr. Curtin on this one in particular, because it's detailed and there's a number of issues that you raise, and I want to make sure that we're absolutely correct and accurate.
Yeah, if you wouldn't mind rephrasing the question so I'm really clear about what it is that you're seeking to get an answer to.
Essentially, the document says that there are significant limitations with the current drug. It says drug testing as a means of managing alcohol or other drug-related risks has a number of significant limitations. A positive test for alcohol and other drugs is not in itself evidence of impairment or impairment of ability to perform or intoxication. So do you agree with your own agency's own policy document?
I don't believe that's a policy document of Safe Work New South Wales. If it is, I'm not familiar with the detail of the document.
Oh, sorry, work cover. Sorry, it's work cover.
It's not Safe Work New South Wales document. So it's important that businesses, PCBUs, reduce or remove harms from the workplace, and where possible, as far as reasonably practicable, take all steps to reduce those harms where they can't be removed from the workplace. Those testing regimes are sensible and useful tools in various industries to get a gauge on those safe systems of work. The mechanisms as to how those things are tested and how they're applied in workplaces will be a matter for each of those PCBUs, and if there's any concerns, they can be raised with Safe Work, and Safe Work can take a look into the controls and the systems that are in place and provide advice to businesses on a case-by-case basis if needed.
Thank you. Minister, would you agree that a workplace environment that is free of risks to health would include the ability for workers to take necessary medication prescribed by a doctor to treat pre-existing conditions, provided, of course, that this means they're not impaired?
Sorry, Mr. Buckingham, can you ask me that question again?
Would you agree that a workplace environment that is free of risks to health would include the ability of workers to take necessary medication prescribed by a doctor to treat pre-existing conditions if that medication they were taking meant they were not intoxicated or impaired?
I'm going to take that on notice.
Okay. What I'm getting at, Minister, is that there are a number of medicinal cannabis patients, an increasing number, especially in the public sector, who are prescribed medicinal cannabis. They are arriving at work. They're prescribed medicinal cannabis for a range of very complex and serious health issues. They're arriving at work. There may be a drug testing regime, or they're self-declaring, and they are losing their jobs, losing shifts because of a drug test or a declaration that they have medicinal cannabis in their system, but that does not correlate with impairment or intoxication, and that's a significant issue for them. People are losing their jobs because of that. And New South Wales, we now have 300,000 people prescribed medicinal cannabis, most of them going to work, and that number is increasing at double digits. It's expected to be over 1 million people by the end of the decade. So do you think that's an issue that the government would needs to be
Definitely. I'm happy to take that, because I know that, and you're absolutely right, that there are thousands of workers that prescribe medicinal cannabis, and we need to make sure that we're, as a government, accommodating, particularly for those people who are undertaking treatment or have got chronic illness. So I understand where you're coming from. I'm happy to ask Mr. Draper, as head of the public service, if we, with respect to the issues that have been raised by Mr. Buckingham, or we can take that on notice, or maybe after the break. Yeah. We'll come back in the afternoon.
Okay, Minister, would you be prepared to meet with a delegation of medicinal cannabis experts and patients who are impacted by the current drug testing regime?
Yeah, absolutely. Happy to make the arrangement to see the delegation, and I'll also have a number of officials with me, as well as seek advice from Minister of Parks, from Health as well. But definitely, and it'll be really important to hear their views, and particularly around workplace issues.
Fantastic. That's very much appreciated. That's my for me done. Ms. Boyd.
Thank you. Can I ask, no doubt you're familiar with the Nowhere to Go campaign from the ETU from 2021. What has been done in response to that campaign and ensuring that we have safe amenities for women in particular at construction sites?
I do have a. You're absolutely right about the issue with respect to women accessing amenities on construction sites. It is part of work health and safety legislation that PCBUs must follow the laws with respect to providing access. I know that, and I wrote to Mr. Curtin about this matter, that we need, when our inspectors are going out on site, to make sure that this is one part, or an important part, of making sure that amenities for women exist. It's against the law not to have amenities on site. And I'm happy to ask Mr. Curtin, because you asked last time, and I know that the Electrical Trades Union, the Women's Committee are running a very important campaign, and it's not just just tradies, but it's also women, whether they're working in factories or they're working in a range of workplaces, and there's a concern, and I've seen the effects of those, particularly older women who speak to me now about this issue, where they have gynecological health issues because of this, and so it's. So I'll let Mr. Curtin.
Thank you.
Sophie, would you mind if I just, before Mr. Curtin comments, I just thought I'd jump in, because when I was until a year ago, when I was at Iron Infrastructure New South Wales, we had sort of convened a group and to run a women in construction program, and we were doing that with the unions, including the ETU and their women's organiser. And in the industry itself. I've lost track a little bit of that because I've changed jobs twice since then, but I'm more than happy to get a little bit of information on that over the lunch break, if you like, and talk about that a bit more this afternoon. But it was, this Safe Work was certainly one of the participants in that program as well.
Thank you. Mr. Curtin.
Yeah, we've taken an active approach to address any challenges that we observe in terms of amenities on construction sites particularly. It's a requirement of New South Wales Work Health and Safety regulations that amenities are provided for men and women on work sites. They're underpinned by the National Construction Code and the requirements in there. And it's also underpinned by Code of Practice for managing work environment and facilities.
How many toilet inspections have there been by Safe Work in, say, the last year or something?
Over the last 3 years, we received 100 requests in relation to amenities at work sites.
And how many inspections have been undertaken?
So I don't have a number that the actual inspections. What we've done is we've changed our checklist for all inspections that we undertake on construction sites to make sure that amenities are part of that process. And I've done inspections myself where we've checked amenities at construction.
And that amenities checklist update, was that updated since the Nowhere to Go campaign, and did it involve talking to the ETU people or to others to ensure that it was...
That update was done in June 2022. Our regulatory practice team updated those checklists back then.
In South Australia, Safe Work, South Australia have really, probably led the nation in terms of this response to this campaign. They've done a very big education campaign, and then they've had a series of compliance checks. So, a real focus on compliance checks. They've also updated their amenities checklist in collaboration with representatives from the ETU. Minister, is that something that you would commit to doing here as well, so that we can finally get some proper action on this issue?
Yeah, I'm happy to, and as Mr. Draper mentioned, he's going to bring forward some information in the afternoon, and the work that we're doing with Mr. Curtin. I wanted to just let you know, Miss Boyd, and the committee, that, and Miss Boyd, you would know this about the concerns that workers are having on the Snowy 2.0. And so on the 20th of February, Safe Work New South Wales responded to a dangerous occurrence at the Marika worksite, part of Snowy 2.0. While on site, Safe Work New South Wales also inspected the Marika camp accommodation facility. And there is a history of inadequate facilities for which earlier compliance notices were issued at this camp and other Snowy 2.0 work sites. Safe Work considers that significant work needs to be undertaken to improve the amenities of the Marika camp, and as a result, 14 improvement notices were issued related to lack of laundering amenities, risk of silica exposure, risks of falls, risks of electrical shock, electrocution, egregious issues, particularly access issues, particularly in an emergency, and you know, other very important issues. Safe Work New South Wales met with management from Snowy 2.0, the joint venture, and Comcare on 22nd of February, and Comcare have committed to taking monthly visits to the sites as part of their contract management. They'll be inspecting accommodation and amenities in the next few weeks. Happy to report back. But this is something that like, it's a big project, as you know. People are living in that accommodation in the camps, and it's something that's been raised with us about amenities at this particular site. I don't want to just let you know. But
thank you. That's useful. Can I ask, Mr. Curtin, when you come back to me with some sort of data, I guess, on numbers of inspections of amenities, how many, so if we could have sort of how many issues have been raised, how many inspections, and then also how many provisional improvement notices have been issued in relation to amenities, that would be really useful, say, in the last 12 months.
Let me take that on notice and see what we've got.
Yeah. One of the issues raised in the McDougall Safe Work report is in relation to under-resourcing. And McDougall comments that he says there's no doubt that the number of inspectors is below the ILO minimum standard of 1 inspector per 10,000 workers. What is our current ratio between inspectors and the workers that are being overseen?
The current number of inspectors, I'll try and pull the number out, but the current number of inspectors is 370. And if you align that to the ABS data for the number of businesses in New South Wales, we need an uplift of about 73 inspectors to meet that standard.
So you need another 73?
Currently, yes.
Yeah, okay. What's the sort of budget impact of that, Minister, do you know, for another 73?
Look, and you know, the recommendations that Mr. McDougall has provided, as I said, is a clear roadmap in terms of what we need to do and where we target our resources. As you know, we're funded by the state insurance. The Safe Work New South Wales funds comes from the State Insurance Regulatory Authority, and there are processes there in place. I think in terms of budgetary value for money, the need to direct resources, the work is currently being undertaken in terms of the restructure of the organisation, looking at a standalone model, and looking at where we can target our resources. I think there's another piece of work that we're currently undertaking with Safe Work, iCare and CIRA with respect to looking at duplication of services. So, like, I understand each agency does particular things, and it may be for under legislative requirements, but some of the things that I've come across, and we're working together with my colleagues, the Treasurer and Minister Chandavong, is how we can use our resources more effectively in targeting. And I think whether it's psychosocial inspector roles where we need to target more effectively, I think this is the work. It's really important work that we're doing, with iCare, CIRA and Safe Work. And so, and this is where structuring the safe work, there's an opportunity there in terms of better aligning our inspectors and working with our other agencies.
If we had, I guess, the reason for the recommendation of the minimum standard of one inspector per 10,000 workers, the more inspectors we have, in an ideal world, we then end up with lower compensation claims through the workers' compensation system. Is that being considered when we're talking about, we have a clear recommendation here of under-resourcing. Just a structural change isn't going to fix that. Will we see more inspectors?
Look, I think that I personally would, I think we need to go through the restructure process and realignment of our resources, and I think that there's an opportunity of a transfer of skill across some of our agencies. Of course, I would like to see more inspectors, and there are obviously we've got to go through budgetary processes, etc. But I think that as we go through this process, this restructure process, one of the other things that Mr. McDougall identified was the specialisation of inspectors. So and it's not going back to the future. And I do understand, and I have taken a rational view and tried to understand, because you have to start somewhere. If you're going to make change, you have to start somewhere in terms of what was the rationale prior. So I guess having the inspectors embedded in this regulatory division, provided I guess the form of government, you have you're undertaking 20 different legislative requirements, etc. You're undertaking all of this work. You've got inspectors that are in building or in fair trading, etc. In some instances it did work, in some it didn't, and this is why the work has started where it's untangling that regulatory. But
we're talking about an extra $15 million a year for inspectors. We could really be stepping up our game and saving people from injury, and then consequently the financial impact of that through the workers' comp system. It just seems like a bit of a no-brainer when it comes to immediate steps to take.
Yeah, and you're right. There's no doubt that we need to have. We've got great people who are out there. Our inspectors do an incredible job. I've met many of them in our regions, and like to their credit, they're doing the very best they can with the current resources that they have. These reports are important to us in terms of fulfilling that roadmap. You are absolutely right, and it's something that we're working on. But I can't give you a commitment here. But I just want to shout out to our wonderful inspectors who do an incredible job. And I know that for some of them, I recently had reports that there were, there's some aggressive people out there, and who, are quite loud and aggressive. And, my message is when an inspector turns up, there's a reason. And no public servant should be treated in any way aggressively, bullied or intimidated.
Thank you.
Thank you, Minister. Just before I go back to the opposition, just in this little bit of time, Mr. Curtin, you you use an acronym. I think it was PCBUs. What are they?
Persons conducting business or undertakings.
Oh, okay.
In the WHS legislation.
Okay, right. So that's
broader term than just businesses.
Sole traders and small business. Okay, Minister, I was thrown a bit when you did say that this is not a safe work document, but a work cover document, but it is on the Safe Work website. So it does probably indicate, Minister, that it might need updating at some stage, seeing as this work cover's long gone. So that was just a comment, really. Anyway, questions from the opposition.
Yeah, thank you, Chair. How much do members of the iCare board get paid?
What do you mean? The board.
Yeah, well, it's a remuneration paid to a member of the iCare board.
I'm happy to ask Mr. Harding for that, or Miss Campbell.
I can answer that question. I'll just double check, but I believe the annual remuneration of all directors on the iCare board is $100,000.
So when you appointed Mr. Morrie, the head of Unions New South Wales, to a position on the iCare board, were you aware that he was proposing to donate his board fee to the union movement? Minister?
For the Minister?
Who are you asking?
You?
Mr. Tudor Hope. Mr. Tudor Hope, you're aware of the legislation. You supported this legislation that we have an employer and an employee representative on the board, and there are processes that were undertaken by Treasury, and at arm's length. So I'll defer to Miss Campbell.
No, I'm just asking you, were you aware that he was going to donate his fee to Unions New South Wales? Did he tell you?
What do you mean? Like, I'm at arm's length of the process in terms of the
It's your appointment at the end of the day.
No, it goes through a process.
But that's right.
It goes through.
There's a process.
It goes through an.
I'm not quibbling that it goes through a
Treasury.
process. Were you aware that he was going to donate his fee to Union New South Wales?
The employer reps.
The appointment of Mr. Morrie to the iCare board was conducted in accordance with Treasury's policy on board appointments.
When
for
did you
government
become aware that he was
businesses,
going to
as
donate
well
his
as
fee?
newly developed supplementary guidelines issued by Treasury dealing with the appointment of nominee directors? And that's my response to you,
Do you know that he was
Mr.
going to donate his fee, to donate his director's fee to Unions New South Wales?
Mr. Tudor Hope, I don't know how this is relevant to the importance of having an employer and an employee representative on the
I'm not
iCare
asking you in
board.
relation to that. I'm asking you, did you know that he was going to donate his fee
But what's
to Unions New South Wales? Do you know that?
yes
or no?
This was an independent process that was
I'm
done
not
through
querying the
Treasury.
process,
I
Minister.
had no. I'm at arm's
Do you
length.
know or don't you?
I am at arm's length.
Do you know
at
or
these
don't you?
processes, Mr. Tudor Hope.
Do you know?
I refer you to my previous answer.
So
You're putting words in my mouth. I have
I'm
no.
not. I'm asking you whether you knew something.
Hang on. These are independent processes that go through that these are independent.
So has there been an
internal
employer
processes.
representative appointed?
There are a number of appointments that are coming up for. There are a number of appointments that are coming up, and the due process will be undertaken. As there are a number of appointments that have been made over recent times on the iCare board.
Thank you, Minister. Ms. Boyd, you've got 3 minutes.
Thank you. I will ask one last question then. The ACTU released a report called Work Shouldn't Hurt, which found that more than a third of workers, so 38% of workers in insecure jobs, didn't take time off to recover from illness and injury. The finding there was that basically insecure work makes unsafe work even worse. Knowing that work insecurity is a workplace hazard, what are you doing, Minister, to provide job security across the public sector?
Well, one of my, other than my own portfolio matters, and no disrespect to my wonderful officials, but I love our policy with respect to providing permanent work for teachers and support staff, and that policy has meant so much to teachers, particularly in our regional, rural and remote towns. The majority of our teachers are female, and also support staff. So we probably 95% of support staff in schools are women, and for many of these women, this is the first time in their life. This is the first time that they are permanent employees, and what that means, and this is particularly for women. What this means is that they have secure employment means that they can go and get a loan for a car, go and get be able to go and rent and provide bond, and some support workers said to me, they said, Sophie, I can now plan to have a family. I've got one child. I can now plan to have a second child because I have secure work. And that means a lot to me, to our society, that the provision of secure work is important because it means that there is stability within a familial household, and that's really important for our society. I think that the insecure work has led to a breakdown of families, of society, and that is because there isn't enough secure work. I think if you look at education, there was 40% of teachers and support staff were casualised. So you had temporary teachers, temporary staff, and that was outrageous. So that's a policy, and I am, absolute credit to the Deputy Premier for doing that. And over the past, and that was an announcement that was made by the Premier and Deputy Premier in opposition, that this policy, 10,000, we would have 10,000 permanent jobs over 4 years, and we have fulfilled that in the last 6 months. And it's actually, in fact, it's over 17,000 people, majority are women, who've applied. And we're doing this across the public sector. I know that Mr. Draper will have more to say about this. The correlation between secure work and having stable family relations, being able to get a loan, being able to plan for a family, being able to go out and be a volunteer, be a coach volunteer, be a PNC involvement, it helps us in our communities. And I see that as a local member, and that's why secure work is important for families. Thank you.
Thank you, Ms. Boyd. Thank you, Minister. Will that conclude... Sorry, Dr. Kane, we have one out of the ether from the government.
Thank you very much, Chair. Thank you, Minister. I wanted to ask about something that was raised earlier, but I want to ask you, what was the actual process of appointment of DLO with the department, DLOs with the Department of Customer Service that was raised earlier?
Yeah, thank you, Dr. Kane, and I really appreciate your question, a very important question. Earlier, the opposition made a number of incorrect statements, and I want to correct them. Firstly, on DLOs, my office asked for a list of candidates shortlisted by the department following their internal selection process. My office requested to interview two shortlisted candidates. This included a DLO who worked in a minister's office in the former government. The departments provided advice that they had a recommended candidate, and I accepted this advice. At no point was a particular DLO requested to be appointed to my office, and as I informed the opposition spokesperson in estimates last year, I have another DLO who formerly worked in his office. Second, Mr. Tudor-Hope stated that a departmental official was moved on. This is absolutely incorrect. That individual, respected individual, remains in their position. Rather, Safe Work began the move into a standalone entity, as was publicly announced as part of the government's long-standing commitments in this space.
Thank you, Chair.
Any more from the government? No? Well, now that does conclude the morning session. Thank you very much, Minister, for your
Thank you, Mr.
evidence
Chair.
and attending the hearing.
Thank you to members of the opposition, government members,
So thank you very
staff.
much.
Thank you to the staff. Thank you to our wonderful officials.
Hansard,
My wonderful
everyone.
staff.
We
Everyone,
are
thank
finished
you.
with the questions. We'll now break for lunch and return at 2 p.m. Thank you very much.
Thanks, Chair.
o'clock. Thank you everyone for returning. We will resume with 20 minutes of questioning from the opposition. Mr. Tudorhope.
Thank you, Mr. Chair. Ms. Dobbins, I'll start with you, and perhaps we can continue to explore the process by which bargaining proposals, I could call them bargaining parameters, I suppose that's the thing, but it's bargaining proposals. Is that the
bargaining positions,
position, whatever
proposals? That's right.
Whatever that. How are they? How do you understand that a bargaining proposal is formulated for the purposes of, firstly, for the purpose of putting it before ERC?
So, as you correctly say, Mr. Tudorhope, there's a policy that surrounds this, and that's premised on the idea that there's now a cooperative mutual gains approach to bargaining. So it moves away from those traditional positional forms of bargaining. Notwithstanding that, there is a process whereby unions and agencies have discussions, ongoing conversations about positions of mutual interest, reforms, productivity improvements, service improvements, things of that nature. When there's then a two-stage cabinet process occurs, not in the sense of how comments are obtained, but a two-stage process to the ERC, where in the first instance there's an approval of agency interests, and then in the second stage there's the final approval of final bargaining positions.
Right. So what's your involvement?
As was the case when you were in government, there is a senior officials committee that assists agencies to work out whether they're compliant with the policy of the day. If they're compliant with that policy, then the SOAC can endorse going forward to have those conversations with between the parties, or if it's beyond the government policy, then we recommend that those organisations, those lead ministers go to the ERC.
So in relation to the paramedics, you would have provided advice in relation to whether the proposal complied with the government's policy, would you not?
There was advice, yes.
And did that advice, was that advice relating to the impact on the budget of the proposal which was being put?
The provision of that advice is not just back to the agency, but part of the cabinet consideration. So I would prefer not to go into the detail of that advice. Suffice to say, we were involved, yes.
Well, you've given evidence that you would, in fact, give advice in relation to whether it complied with government policy. So, in relation to that proposal, did you provide advice in respect of whether it complied with government policy?
As I say, advice is not just to the agency, it's also to the Cabinet Committee, and advice was provided in that process.
Well, let me ask you in relation to the fireys. Have you provided any advice to the department yet in relation to a bargaining proposal?
My understanding is they're not quite at the stage of finalising a set of interests or a proposal yet, but we are engaging with the agency with that process to assist them in that process.
So, it is fair to say, is it not, that no bargaining proposal has yet been developed for the purposes of trying to finalise an outcome in relation to the fireys?
Not in the sense of the former policy, but the current policy is a less... you don't need a bargaining proposal up front to commence negotiations. Negotiations, mutual gains bargaining, is an ongoing thing, and at the time when the parties have agreed a set of interests, as I say, productivity improvements, service improvements, reforms, that is the point where you may need to go to the senior officials group or to the ERC to get government approval.
Well, have you received any draft bargaining proposals?
I believe the agency has received something from the union in regards to what they're looking for.
But have they developed any?
Sorry, have Fire and
Has
Rescue?
the agency developed any draft bargaining proposals?
I'm not part of those negotiations, as I'm neither the employer nor the union, but I believe there's been
none have come to
a
you?
discourse. But none have come to me, no.
Not even any draft bargaining proposal. See, if I take you to the document, it requires agencies will consider, prepare and submit draft bargaining proposals which identify interests and opportunities for reform for approval of the Senior Officers Working Group in a timely manner and sufficient flexibility to meaningfully participate in mutual gains bargaining. So,
They're in the step before that, is my understanding.
Well, you've identified that step as the mutual gains bargaining, and you've identified it as being different in the sense that it tries to reach outcomes in a more informal way. But if you're going to have mutual gains bargaining, you've got to have at least a draft proposal that you're working on. Would you agree with that?
The agency may well have that, but that does not mean that me and the central agency would have access to that or knowledge of that, because it's for the parties to, as you say, informally come together and mutually decide these positions of interest.
So, well, may I ask you this? In relation to other proposals, at what stage would you expect a draft proposal to be available in relation to the negotiation process?
It's very difficult to answer because the policy and the approach is so new. So there's not a lot of precedent that I can rely on, and it's a more fluid and informal process than it was before.
Well, if the agreement is going to terminate in February of this year, wouldn't you have expected at least a draft proposal before the agreement terminates?
Look, I think that's calling for my opinion, and it's not for me to have an opinion here.
Well, you've been doing this regularly enough now to know what the timeline is in respect of the manner in which draft proposals would be made available. In your experience, would you have not expected, before the termination of an agreement, a draft proposal?
Point of order, Chair.
Point of order has been taken, Dr. Kane.
Ms Dobbins has already answered ostensibly the same question and noted that it was asking for a question. The rephrasing still pretty much asks for Ms Dobbins' opinion in this.
No, I've asked her to reflect on her experience.
Yes, but to the point of order, I'll rule. But yes, you were asking the witness to reflect on her experience, but also I do think you were asking for an opinion within that.
Well,
if you could reframe it, Mr. Judah Hope.
In respect of the paramedics' decision or agreement, when was the draft proposal first prepared?
I'm terribly sorry, I don't have that detail in front of me.
You don't know?
I don't know.
Was it before the agreement terminated?
I can't recall. I'll have to take that on notice.
Well, in relation, how many agreements have you been involved in since the current government came to the power?
Personally, or
yeah, well, in
the
terms
branch?
of being involved in the drafting of bargaining proposals.
Across the branch, it would be many. We assist agencies and
How many
shadow
of them?
agencies.
How many of them would have started with proposals after the agreement terminated?
I'd have to take that on notice. Look, it's not unusual for especially in the case of fire and rescue, where the previous award was only settled late last year, for this new consultation and bargaining round to be so late in the piece. I agree it's not ideal, but it's not unusual, and it's certainly not, doesn't preclude the parties having these conversations under the policy now.
So it's not desirable, is that your assessment?
I would say it's not desirable for either the agency, the employees, or the union members, no.
Well, so what we do have you had any discussions with the Department of Customer Service? And perhaps I could go to you, Mr. Head. Where are the proposals up to in relation to the bargaining agreement?
In respect of the fire,
is that within
that's
your...
not a matter for me, I'm sorry. It's a matter for the relevant emergency service agencies, not for the department.
And that is, Ms Dobbins? It's
So
Minister did, but...
fire and rescue
Fire
are
rescue.
in Department of Communities and Justice.
Okay, well, we'll ask them that question. Just in relation to the preparation of agreements in relation to your department, Mr. Head, how soon do you expect to draft bargaining proposals?
I'll need to take that on notice, Mr. Tudor-Hope. I'm, as you know, about 12 weeks in, and that's not something that's been at the absolute top of my list to attend to yet, but I'm happy to come back to you with information on that.
And I'll ask you, Mr. Draper, what's your expectation of the drafting of bargaining proposals for various enterprise agreements, in terms of what an expectation would be?
Well, I think Ms Dobbins has set it out pretty well. The policy that the government has now involves, as you know, a bargaining process, and that involves quite a lot of discussion up front. So bargaining proposals in the form of specific wage movements or other conditions that might be pursued either by the employer or by the union, that's not necessarily the starting point for those discussions. So there's a bargaining policy that's been included in our policy now, the adopted, the policy of the new government, and that's really the starting place. The bargaining proposals that you're talking about, which are, I'd call them the hard conditions, the wage movements, etc. The process for that is for it to go through the senior officers group, for a submission to be prepared by the Portfolio Minister and the Minister for Industrial Relations to ERC, and for ERC to approve those conditions. That's a much more formalised process, and it may not happen until there's a much stronger understanding of where the two parties are at.
Thank you. Can I just take you, Ms Dobbins, to the development of engagement councils? What work's been done in relation to setting up the Peak Engagement Council?
We're at the preliminary stage of providing advice to the Minister's office on the mechanisms for setting up those councils.
And that advice, how do you see the structure of the Peak Engagement Council?
As set out in the legislation, I'm not sure I've brought that note with me, but as the legislation sets out, sorry, if you just hold on for 1 second, I think I've got...
Yeah.
So the purpose being to provide a forum for ongoing dialogue about the fiscal position of the state, performance of agencies across the sector, and track bargaining outcomes. So advice in how to set up the councils to achieve that.
Well, tell me what that looks like.
I'm sorry, as I said, we're at a preliminary stage.
Not a lot of work's been done.
Possibly it has within my branch, but I'm not across the detail, I'm sorry.
Well, in terms of setting up the, how do you anticipate that they would engage with individual agencies?
As the Minister was saying this morning, I think in some respects it won't be dissimilar to the joint consultative committees that already operate within agencies, but the purpose is to embed the government's bargaining approach of mutual gains bargaining. So it would be designed to bring out those joint interests between the parties to assist with agreements to be made.
If I can ask you this in relation to what you say is a mutual gains bargaining, what do you understand the expression mutual gains to mean?
So mutual gains bargaining or interest-based bargaining, and I don't profess to be an expert in it, but my understanding is that it's a non-confrontational, non-combative approach where parties come together and discuss areas of mutual interest. So start with things that might be issues or concerns or reforms that they want to be made and try and work through those things to a mutually beneficial outcome.
Well, one of the things that you're required to have some cognizance of is the impact of potential wage rises on the Essential Services Fund. Is that something which you would take into account?
So I'm just
as
trying
part of the mutual gains bargaining and setting out there and reaching an agreement, do you also take into account impacts on the Essential Services Fund?
Within agencies, obviously they have an eye to fiscal responsibility, and then yes, the senior officials group, the SOAC, and absolutely the Cabinet, and then ultimately the Industrial Relations Commission have to have an eye on the fiscal and economic position of the state, yes.
Correct. And in relation to the agreement which was reached with the paramedics, did it have an impact on the Essential Services Fund?
I must say that information, that input, advice, if you like, in relation to the fiscal and economic position of the state, that's provided by our Treasury colleagues as part of the SOAC process and the ERC process.
Did you receive that advice from Treasury?
Beg your pardon?
Did you receive that advice from Treasury?
The Cabinet would have.
You didn't? Did the senior officers group receive it?
I'll have to take that on notice. I don't recall.
Whether you received advice from Treasury in respect of a proposed agreement and the impact on the fiscal position of the state?
For paramedics?
Yes.
I don't remember.
Really?
Really?
Well, do you recall whether you received advice in relation to any productivity enhancements?
Yes, we did receive advice in relation to productivity enhancements. Largely, the paramedics issue was a consideration of a work value approach, and so there were a range of work value enhancements that were looked at as part of the process.
So you, in fact, took a view that in relation to work value enhancements, and I take it that work value enhancements is recognition of tertiary qualifications and the like that the Minister referred to in her evidence earlier.
That's correct.
You took the view that qualified as a productivity enhancement for the purposes of breaching an agreement, did you?
I wouldn't like the assumption to be made that it was only the senior officials that made decisions here. It was part of a Cabinet process, and the Cabinet would have taken into account things of that nature.
Well, let me ask you this in relation to your input as the part of the senior officials group. When this sort of, did you form the view that those things comprised productivity enhancements?
So as you know, under the fair pay policy, unless it's within the 4% plus superannuation, the senior officials can discuss it and consider it and have a view on it and provide advice and information to the Cabinet, but we were not authorised in that instance because of the quantum to be the approval point. No.
Well,
So, yes, I recall along the way we would have discussed fiscal impact, productivity improvements, etc. But ultimately, it was a cabinet
So
consideration and decision.
what was your definition of a productivity enhancement for the purposes of that agreement?
Well, it's the kinds of things the minister discussed this morning.
So your position is that it was a product, that an additional tertiary education was a productivity enhancement.
No, that's not what I'm saying. What I'm saying is the SOAC would have looked at things of this nature as described by ambulance and health as part of this process, but ultimately it was not. We were not required to make a decision as to whether those productivity enhancements existed, didn't exist, contributed to the ultimate pay increase that was given. That was a decision of the Cabinet.
I'll come back to it.
Okay. Thank you, Ms Dobbins. Ms Boyd.
Thank
20
you.
minutes.
Thank you, Chair. If I could turn to you, Mr Harding, to talk a little bit about eye care. I'm just looking firstly at your annual report for 22-23. I note the performance scorecard starting on page 11. Although a lot of those targets are being met, there were a couple that jumped out at me. Just that top one, the customer satisfaction targets.
Yes.
Are you able to talk a bit more about, so we have 1 out of 5 of the CSAT cohort targets being met. Can you talk us through what wasn't met and why, and where the sort of the points are, and
Yep.
you know what you're doing to fix it, I guess.
Yeah. And we've had some of this conversation before, Ms Boyd. So we set ourselves at a enterprise level that scorecard, which sums up, if you like, each of the individual scheme level outcomes that we're trying to achieve. And with respect to the CSAT or customer satisfaction measures that we're trying to achieve, we've set ourselves targets to continue to drive improvement in those. And what that scorecard is simply saying is that we only met the goals we set ourselves in 1 out of the 5 schemes that we set the targets for. If you turn to other pages within the report, so for example, for the workers' compensation scheme, for the workers' compensation scheme, page 47, you'll see the individual customer satisfaction ratings there provided for that specific scheme. We set ourselves, for example, a target. I'm going to give you a round number here because I don't have the specifics in front of me, but of, for example, 72, rising from a 69. I think we didn't achieve the 72. I think we ended up at 70. And obviously we have activities, as you say, now in our current plan going for this current year to continue to improve that. And those are ongoing pieces of work. You'll see on page 46, opposite that chart, the underpinning of that is also the professional standards that we're rolling out for case managers across the CSPs that we utilise in. I'm really talking workers' comp specifically, but we could have this conversation for each of the schemes to try and drive improvement in the outcomes. And they tend to form around 3 key areas, or 3 higher level areas. So communication, how we're actually engaging with people, follow up, do we call them back on time, all those sorts of things that we know really can aggravate people and not enable them to move through the process very well. The process itself, where there are barriers in the process, how we can remove those, and then knowledge, right? And the professional standards try to bring those. So, was the person actually able to deal first time and solve the injured workers or the employer's problem? So there we have a string of activities across the schemes, and each scheme has its own plan to try and continue to uplift those. Obviously within the nominal insurer, specifically the workers' comp scheme, we do that through the claims service providers as part of their contracted engagement with us. We have a set of base fees that we pay, which is really an expectation, which is set around about 95% of their fixed costs. Then we have what we call quality fees, which really include this measure of customer satisfaction. So how are they delivering the outcomes to customers? Is it, customer satisfaction? Are they meeting the legislative requirements around, payments within 7 days, all those sorts of things? And then the incentive on top of that is a third component of the fee, which is then about return to work and the outcomes of actually delivering the benefits to people. So we've got all of those activities going. The scorecard and the way we've related there at an enterprise level probably doesn't look particularly attractive, but it's an ongoing area of work. If I talk to you about another place that's relevant here is complaints.
Sorry, I'll give you the chance in a
that's
minute.
fine.
I'm just curious, how does that track if we looked at previous years? That target, is that...
Well, this is the first year we've done it that way. So,
okay,
but
all right.
That's why we've included the example I gave you on page 47,
so
where you can see the history of each element. So we've got, policy is employers taking out a new policy. Employer claims is how employers feel we're managing claims. And then obviously injured worker is injured workers. And you can see, you see the policy, the employers taking out new policy is something we've had a lot of success with. We've digitised that process. It's very it's a lot better. I won't say it's very convenient. I'll say it's a lot better than it used to be. We're now focused on doing similar things for injured workers to drive that performance. Sorry, my apologies. And you can see that for each of the schemes, going through. The TMF, for example, is on page 62, and we can keep going through it if you like. So each scheme, we try and provide the history there to make it relevant. And I think what we've learned probably in putting this annual report together is that corporate scorecard or enterprise scorecard is really not that useful because it doesn't give, it kind of brings things up to a level that's not relevant for each of the schemes. So we'll probably leave it at reporting it as we have in page 47 and so forth.
So keeping in mind that it's not been going for that long then, I understand you've got 6 new claims providers being brought on.
Yes.
Do you think that that's going to put even more pressure on this particular target, or are you putting in place...
No, we're hoping it's going to shift this target up.
Okay, all right.
So maybe if I...
Just in terms of the professional standards training and everything else to bring everybody...
Yeah. So we've been very conscious as we've transitioned from one provider, EML, to the 6, to do that in a way that we don't disrupt for injured workers in particular. And I'm really... happy to say that we've had a good experience at that. So we haven't seen a material shift in return to work, for example, over the sort of 12 months that we've been moving claims away from EML. And similarly, we haven't seen a material shift in CSAT. It's quite volatile. It goes up and down. Obviously, as we bring those 6 CSPs on, we are bringing in new case managers into the system. And there is a development opportunity in that to get them consistent with the professional standards I've talked about. But our ultimate goal is that those 6 providers, because we now report on our website the performance data that I talked about before. So there is return to work for each CSP. There is CSAT for each CSP. We will ultimately report on professional standards of the capability levels. And the case levels for each CSP, so what's the case loads that they have, and try and give employers and injured workers much greater insight into the nature of the skills and capabilities of the CSPs themselves, so they can make better decisions about those, but ultimately to drive the competition to get those performance levels up to improve outcomes. We have as one of our core strategic pillars going forward, we've just reset with our board on Monday, our strategy for the next few years. And one of those is delivering fair and empathetic interactions for the people we serve. That's not just workers' comp, that's across the scheme. And so it is core to what we're trying to achieve in the way we're trying to drive performance across workers' comp, TMF, and the other schemes. And we have a set of activities around trying to deliver that is all based around how we create a much more effective human-to-human engagement. And some of that will be about automating the non-human necessary things. So there's a lot that's in the scheme. We've talked here, and I'm talking on, so now if you want to stop me. There's a lot in the scheme that we've talked about before where a prescriptive nature of the regulatory environment and the prescriptive nature of the legislative environment makes the case manager's job very difficult in terms of trying to create that human-to-human contact. So the first point of call, for example, that first phone call in, and you were talking earlier with the Minister about that repetitive re-injuring of traumatic injury. Well, the first call, that case manager has 30 different regulatory guidance notes to try and live to. And they each provide some level of information about what data they need to capture, what they have to do in that phone call. So if you think about a mid-20s, early 30s case manager who's trying to get themselves ahead, they're struggling to get through those 30 whilst being a human being to someone who's had a traumatic injury. And that's we're expecting a lot of that individual. So our goal is to try and automate as much of the non-human to human bit to free up the time for the case managers to be able to be empathetic and caring and deliver that outcome. That's going to take time. Automation is not going to happen tomorrow. The legislative framework has to be thought about in that context. So there's a lot to get through to get us to a place where we can deliver the sort of outcomes our Minister wants, and I know that you're interested in as well. But it's on the plan, I suppose, is what I'm trying to say, in a long way.
Thank you. I wouldn't be estimates if I didn't ask you about consultants.
Yes.
So looking at the last annual report again then, so and I've done the rough figures, and apologies because I know that there was some changes to the previous disclosures, and I'm not sure if my running figures are capturing those or not. But
if you've done running figures, you're ahead of me. So.
All right, good. It looks to me like consulting, total consulting spend is up just over 31% on last year, on the year before. What do you attribute that to? So we've got just under 19 million, which is the second highest figure for the last 6 years.
I might ask Mr. Farquharson to answer some of this, but I'll give you a high level sort of my perspective on it. So I think as we talked in your previous committee about consultants, the majority of what we spend money on is the actuarial services to deliver the valuations, the liability valuations for each of the schemes, and that generally accounts for about $9 to $10 million of the annual spend.
That one was quite modest. That's an 8.86% increase in the year before.
We've actually, since the last forum that we talked to you about that, we've actually reviewed all of that, and we're now in the process of looking to insource some of that, which again, Mr. Farquharson might like to talk about a little bit. The things that are probably driving this increase is the improvement programs that we're running. So we've had Promontory do the work on the assurance of the implementation of McDougall, and that unfortunately is a reasonably expensive exercise. And we've also then used other consulting services to support some of the change work we're doing. I don't know, Stuart, if you have a more detailed answer that we can give, or...
I do, and I'm not sure if it'll be helpful or not because you've covered most of the points there, but the starting point is that the actuarial services, so we use the third-party actuaries to support us in our half-yearly reporting, so they do the valuations and
that's relatively stable.
It's half of the cost on average each year, so about $8 million. And as Richard mentioned, there are benefits to bringing that in-house and doing that ourselves, and so we're currently doing that for some of our schemes, and if we do that well, it should be very good for the organisation. We'll enhance capability and hopefully use that to enhance how we operate and manage our schemes, and of course we'll hopefully do it in a more efficient way too. So that's important. The bulk of it, or the other half really, is about that transformation program. There's been significant work in that over the last few years. So that's been a large amount of the increase. So there's the workers' comp claims model, the TMF general lines claims strategy.
Is that the Accenture 700,000 just over amount claims service model and risk management advice? Is that what that bit of work was in relation to?
I can give you the names of the individual engagements. You might just have to give me a few minutes to get to that. But I'll just go through the list of the other areas, and then we can go to the firms that provided the services. But some of the PRE review work that we did some work on our data strategy, and we've invested some time in our employer and program support areas.
Perhaps I can just ask some specific questions about some of these then. So we paid Deloitte just under 200,000 in relation to that remediation program to address the underpayments. And I know I asked you about that during the consulting inquiry, and there was a number of different payments to consultants for that project.
Yes.
Is that the last of them? Is that the...
I believe
solved that now?
I believe so. Maybe I can come back with that on notice if you'd like.
Thank you.
We've obviously had further engagement with Deloitte around the indexation issues that we've been dealing with this year. But in respect to PRE, that would be the last, I'd say. So let me come back to you with specific answers on that.
Thank you. Mercer being paid investment management consulting services just over 800,000. Is that an ongoing management? So are we expecting to pay that sort of amount every year, or was there something special about this year?
No. So Mercer's are contracted to advise the board. So the board under the State Insurance and Care Act, Governance Act, SIG Act, have an accountability in respect to determining the investment strategy for each of the funds. That investment strategy is then implemented via T Corp.
I thought so.
Right.
Okay.
And so Mercer's role is advising the board. So T Corp bring proposals.
Yep.
The board needs to make an assessment of those proposals. Mercer's there as an independent advisor to create a value, if you like, to say how is the T Corp proposal and strategy going to meet the needs of the scheme that they're proposing it for.
Okay.
So they provide advice to the board in that context. It's actually we've recently again Stuart has recruited a new chief investment officer who's really going to undertake that role in-house from now on. So we'd expect that that probably would decline over time, I think, in terms of the need for that truly sort of outsourced.
What else are you looking at insourcing then?
Well, we have an ongoing review with our good friends from Treasury happening, and there's things in there which we were going to do anyway. Which is not on this page around consultants, but we do spend a lot of money through contingent engagements in respect to our IT systems development work. And we believe that there is an opportunity there that will both enhance the quality of the IT changes that we get delivered and reduce the cost. But it's a very early proposal. It's nowhere near as developed as the work Stuart's been doing on the actuarial side.
Yeah.
But that would look to reduce our contingent spend quite considerably and give us a more stable and quality outcome from a IT change perspective.
Your contractor costs were also up about 10 million over that period.
Yeah.
Is anything being done to reduce that?
Yeah, they're already on the way down. So I got it somewhere. We had a lot of contractors in at the very early start of the work on McDougall remediation, and that is now tailing off, and it will be gone by June. Largely the increase that's been there.
Okay.
And it's another element of the work we're doing with Treasury around how we can continue to reduce that. We've brought long-term contractors. We've been converting back into employees. Those sorts of things.
So what's that in terms of headcount then? If we're looking at extra 10 million, how many people is that?
In the actuarial area, or
just that in the contractor spend? if it's gone up by 10 million in a year?
So I'm just trying to find it for you. No, it's consultants. I'm not sure we've got it for you. And I could give you some off the top of my head numbers, but maybe I'm better off giving you something
That's
coming back.
fine.
Abigail, what was the question? What were you trying to get to?
I'm trying to find out how many additional contractors you've employed for that additional 10 million in cost.
Okay.
Yeah, obviously, I'm keen for the consulting value to go down, but I don't want it to be compensated by an increase in
So maybe give you the overall picture is, at the moment, the whole work that we're doing collectively is reviewing each of these areas, consultants, contractors and contingent workers, or vendors is another way of talking about those guys, and looking at ways, different models for how we can bring a better outcome from each of those spends. In the terms of the contractors, what I just don't have with me is the base that we started from. We got up to about 220, I'm going to say, roughly. We're now back down at about 190, but again, by June, that should be back at the sort of baseline that we were historically.
Understand.
Okay. I just don't have the original starting point for you, but let me bring it to you in...
Thank you.
I can just picture the page in my head. I just
No
don't have
worries.
it.
Thank you, Mr. Harding.
No problem.
Mr. Tudorhope.
A bit nervous about asking Mr. Harding a question. If I can return to you, Mr. Dolan. There are two principal provisions in reaching bargaining parameters which you engage in, and that's in respect of remuneration, and that is set out in clause 3.1, I think it is. 3.1 of your wages policy, and then if you go down to 3.5, it says additional enhancements to remuneration or other conditions of employment. Maybe it's a bit of whether associated costs is offset by savings, and then such proposals must be submitted for consideration to the Senior Officials Wages Advisory Committee for assessment before proceeding to ARC. What do you say in relation to the paramedics were the proposals which were submitted for consideration to the Senior Officials Wages Advisory Committee?
So, as it sets out in the policy, there's increases can be granted, as you say, when the conditions under clause 3.5 are met, or they can be granted when the conditions under 3.4 are met, whereas an additional increase may be provided where parties identify substantial efficiency improvements, including changes to work practices and work systems, which provide demonstrable enhancements to delivery of services to the public. The SOAC can have regard to those two things.
Good. So
In relation to paramedics, there's no doubt that the SOAC would consider and endorse submissions where one or either of those conditions are met. However, the final approval for enhancements is a matter for the Cabinet.
No, I got for ERC probably, isn't it?
That's correct.
Yep.
That's correct. The ERC, and in the case of paramedics, it went quickly to that forum.
Right.
The matter went quickly to that forum, and can't disclose the discussions in that forum, but
No, you
I
can't,
can
and
assure
I don't
you.
expect you to.
No, but I can assure you.
But there must have been some proposals which came to the Senior Officers Working Group.
And the proposals were in the nature, and I can read out the types of things, but the Minister was discussing this morning. So it was those changes to paramedical practice, requirements on paramedics in relation to university qualifications and registration requirements, the development of new protocols and new pharmacological and clinical interventions that they undertake, enhancements to clinical practice, including increased expectation to identify acute stroke and implement hospital measures with improved neurological outcomes, use of oxytocin in normal childbirth and management of postpartum hemorrhage, verification of death, and increases in mental health care. The Mental Health Act now grants paramedics who have successfully completed mental health training powers to detain, restrain and search mental health patients. So it was service enhancements of that nature.
So did you form a view about the benefit which would be derived in relation to each of those things which you have just identified?
Did the committee form a view?
Yeah, that there is the financial benefit
We
or the savings which those things which you've just got through, was there an assessment made in relation to the savings which each of those items would have delivered as a result of the new agreement?
We formed a view that it needed to go to the ERC.
Well, I know you've formed that view because that's the part of the process, but I'm asking you about, did you form a view about the savings?
Not sufficient for the committee to grant the approval. It had to escalate to the ERC.
Thank you, and that is the answer which I wanted from you, because if you go to clause 5.2 of your agreement, of the policy document, it sets out the principles in relation to enhancements to productivity. You see all that?
Mm-hmm.
Did any of the things that you've identified in relation to the paramedics fit within the definitions of enhancements to productivity which is contained in those provisions?
I do need to be clear, Mr. Tudhope. This is a policy. It's not legally binding. We adhere to the policy as best we can, and
Well, did it adhere to the policy?
where the parameters of enhancements to productivity or those earlier clauses we talked about are discussed by the committee, and we believe it's more appropriate for a committee of the cabinet to give regard to those things or consider those things. It goes to the cabinet.
So, in terms of when you assess, I take it the issues relating to the compliance of the document with the policy. Did you make that assessment about whether the agreement which was put before you complied with the policy document?
We concluded that it was a matter for ERC to discuss.
Okay. There's a training contract which I think you identified earlier today, and I think that training is provided by who?
That's correct. I've got the information you were asking about this morning.
Good, thank you.
So at this stage, the mutual gains bargaining training is a voluntary training program about how to conduct mutual gains bargaining, and it's organised for both agencies and unions. And the facilitators are a group of independent mutual gains bargaining experts and practitioners led by the Resolution Institute, which is the main contracting party, and an organisation called CoSolve Proprietary Limited, and they've been engaged to deliver the training.
And is there a fee payable for them for that service?
That's right. So they were engaged under pursuant to the Procurement Performance and Management Services scheme, so one of the public sector procurement schemes, and to date 5 training sessions have been conducted, and the total cost of their professional services for workshops to date has been $69,850, including GST.
Was there a tender process in relation to the provision for those services?
Pursuant to the requirements of that scheme, only one quote was required because the fee was below the $250,000 threshold.
Thank you. Mr. Harding, can I ask you in relation to the Home Building Compensation Fund? Must be one of your favourites. What risks do you see in relation to that fund in the 22-23, 23-24 year? Well, perhaps I could suggest to you that potentially the biggest risk, of course, is insolvencies or liquidations.
Yes.
You've had two large insolvencies or liquidations, to the best of my knowledge. That's Oracle and Emerton Homes.
Yes.
So, in respect of I suppose, budgeting going forward, what are you provisioning for in respect of claims on the fund, in respect of liquidations or insolvencies?
Thank you for the question, Mr. Tudor-Hope. Maybe I just clarify around the current insolvencies that we've experienced over the last year. You mentioned Oracle and Elderton.
Yep.
There was also Allura Homes. Porter Davis Homes was largely Victorian, had no real impact. A company called Privium.
Yep.
There's been quite a few in the past.
I recall that one well.
There's been quite a few in the past 12 months, and you may have seen the news that yesterday the further Cubits granny flats went into insolvency yesterday, which we're still gathering information on. So obviously the stressed environment of the building sector is a major issue and impact for the scheme. There's still a lot of hangover from the COVID period where fixed price contracts and the inflation that incurred through post-COVID environments significantly impacted building construction. I think I've talked at this forum, or perhaps at one of the other forums, about that iCare and the HBCF scheme does a assessment of the financial sustainability of each builder, meeting the criteria that is set through CIRA.
How often is that done?
Every 12 months.
12 months, yep.
And we've seen the utilisation of the amount that we allow increase significantly over the sort of last 3 to 5 years. And that would suggest to us that there isn't much financial capacity in the building sector at the moment for further risk to be taken. So we allow within our liability valuations for large insolvencies around about $130 million. That's been consistent for the last however many years. And we also allow an amount, which I can't remember off the top of my head, but a smaller amount for small insolvencies. At the moment, our experience is very much the smaller insolvencies that were happening last year. As we talked about, those large insolvencies were the biggest impact. So I think we would comfortably say that from our perspective, the sector is moving through the challenges it's had, but there's still risk there and there's still pressure.
So would you anticipate then that the premiums in relation to home building certificates will increase?
Well, they increase generally because the cost of construction is increasing, even though there's a cap in that. But I don't expect it to be very significant this year. I think it should be more inflationary, not a more significant increase. Now, we haven't yet done that work, but generally, from what we're seeing, it's not really causing concern beyond the sort of normal inflationary levels of change.
Well, the net claims or expenses or schemes, there was a significant, I suppose, deterioration in terms of the number of claims being made on the scheme.
Which really is those large insolvencies we've talked about. But they would have been provided for within the pricing and within the reserving.
Well, the underwriting result was also down, was it not?
Yes.
So, if that's going down, isn't the underwriting result also then going to, at some stage, impact on potential premiums?
Yes, it will, but it's a timed issue, as you might recall, over time. So I think I'm trying to assess this. I don't think there's going to be a knee-jerk reaction in the pricing of the current stresses in the system.
but it could potentially impact on the building cost going forward if in fact the cost of the building or the building insurance certificates are in fact increasing. That's self-evident, is it not?
Yes.
And when the building industry is under threat in relation to that, potentially what we are seeing in terms of I suppose increased insolvencies, then that's a given that potentially for the purposes of insurance it will increase. Have you identified, without giving any, are there building companies you've identified as part of your review process where you have in fact identified a significant potential threat in relation to their solvency?
Well, as we mentioned before, we do an annual review for each one. We have a subset of the portfolio which we do a more frequent review of because we have concerns about the nature of the risk.
Yep.
And
how many fit into that subset?
Well, I couldn't tell you off the top of my head. It's not a large number.
Yep.
It's a small number. When you think about 22,000 builders, it's a number in the hundreds, not a number.
And potentially the ones most at risk are the smaller ones, are they not?
Not always. It's the more complex, larger ones who tend to
take on more than they can afford.
Yeah. But so we do those more frequently, and that will be dependent on their own position, that the frequency of that review. We also have, in the past, as we did with some of the ones we just talked about, including Qubits, we actually can restrain the amount of business that they do.
Yes.
So that there's fund. So consumers aren't exposed, but also the fund isn't exposed. If we see that their sustainability, their profit margins are shrinking, their long-term sustainability, the trends in their business aren't looking positive, we can reduce the amount of capacity that they have to do new business or do more building until such time as they get their finances in order to enable that to happen. So we have a number of mechanisms within that SURA-regulated environment to manage those higher risk.
Well, just for my benefit and for the benefit of the committee, what are the mechanisms that you do put in place to manage that?
So we can, as I just said, we can reduce the amount of capacity they have to build or continue to build.
Yep.
We can require them to contribute more assets or into the business so that the business has a more sound financial standing. We can suggest to them that they do work, and we work with them very collaboratively to do work on financial restructuring to help them get better outcomes from that. So they're the sorts of things that we can do. The most pecuniary, of course, is limiting the amount of new building work they can do.
Or alternatively, making sure there's the asset backing for
Indeed.
the purposes of making sure that,
That's right.
that they can meet any liabilities which they have. Can I turn then to iCare itself? What's the current for the purpose of the net asset holding policy, which requires a transfer of funds, what's the current ratio that you're operating at?
Can I just clarify the question, Mr. Tope? What's the current operating ratio for the scheme, or
what's the current operating
ratio does the NAHLP kick in at?
No, I know it kicks in at 105%,
right, okay.
105%. So what's the current operating ratio?
105 at year end.
So at the year end it was 105 exactly.
At the year end?
Yeah. 30 June last year, 23.
So what funding ratio are you anticipating for 23-24?
Well, we're still working through the December valuation process. We had a discussion with our board on Monday. There's more work to do before we finalise that and get to a position where we will be able to communicate with Treasury.
Well, Treasury are indicating about 99.38%.
99.38%. As a funding ratio?
Yeah.
Well, I'm not sure where that's from. But
well, in the half-yearly review.
Oh, that would have been a view some time ago. the half-year review would have been done.
Half-year review was in December.
Well, as you know, Mr. Tudor, sometimes
Yeah, I know.
we get asked in October for something that's not going to actually get out until November. So I wouldn't put too much weight on that number, and I don't have a number to tell you for the 31 December at the moment.
Okay.
I mean, we can probably perhaps give you that on notice because it'll be, it's
The
not far away.
22-23, what was the contribution required to be made to the top-up, so-called top-up to the TMF?
Last year, maybe Ms Campbell has it to hand before I do.
669 million.
That was the bailout that had to be made, was it?
Oh, sorry. Sorry, what was your question, Mr. Tudor-Hope?
Well, the bailout, isn't that the
Yeah.
Previous opposition Treasury spokesman called it
Yeah,
bailout?
I've got it now, Mr. Chair. So yes, 667 million
Yep.
was the grant provided under NAHLP, and that was related to $200 million increases in the police medical discharge claims, the July and October floods of about $150 million, and the increasing institutional child abuse claims of $500 million.
It doesn't seem to vary much, does it?
Oh, well, what I can tell you is I don't think those pressures have changed a lot.
Yeah. Generally, in terms of managing the claims in relation to the team, but there are a number of things that you can do to manage it. Some of them are operational, some of them your investment strategy.
Yes.
And some of them are the manner in which you have policy parameters relating to the manner in which injured workers qualify. Are there any proposals to change those qualifications for qualifying for compensation as an injured worker?
Within the workers' compensation system?
For example, under mental health claims?
No, other than the presumptive conversation that was held earlier with the Minister, which is largely relates to the emergency services groups. There's no that I'm aware of. There's probably a conversation with Sarah. There's no proposed changes to entitlements or benefit access for mental health injuries that I'm aware of.
Have you done any modelling in relation to the impact of presumptive claims?
We have done the modelling that I mentioned earlier in respect to the proposed firefighters' cancers and to the PTSD work, which we provided to the Minister and to Treasury, and we've also provided to logically Sarah, and it's Sarah really who needs to take it forward from there.
Mr. Tudor, there's no crossbench questions, so you're free to continue on until 3:30.
This is
or not?
No. One of the presumptive claims which was previously legislated were presumptive claims in respect of COVID. What is the current circumstances in relation to presumptive claims in respect of COVID?
Well, the presumption still remains in place.
Yep. What's the impact on the fund?
We haven't done another sort of hindsight view of that, Mr. Tudor, so we haven't sort of looked at. But as you can imagine, COVID claims have declined significantly. The intent at the time was really about dealing with frontline services providers who were exposed. We are not seeing it as a major issue in the scheme today.
Can you just go through with me for what the current return to work figures are in relation to workers' compensation claims?
Yeah, I just need to find it. Do you have a specific area that you'd like to talk to, or?
Well, the long-term claims, the long-term return to work. What in terms of workers' compensation or personal injury claims, what are the current figures in relation to return to work or?
Yep.
How many are there in relation to, say, 28 day, 60 day, 120 day?
Yeah, I'm just trying to get you the number, sorry. Right. In respect to the normal insurer, the current 52-week, if that's long-term enough for you, is 88%.
Yes.
In the Treasury Managed Fund, it's 86%.
Right.
And that's the rolling 12-month SIRA measure.
So what was the time period you just gave me?
It's rolling 12 months to June 23.
Yep. So 6 months.
So the 26-week measure is at for the same period is 86 for the normal insurer.
Yep.
And 87 for the Treasury Managed Fund. Do you want me to keep going back for you? So the
Yes,
13-week measure is 81% for the normal insurer, 83% for the Treasury Managed Fund, and the 4-week measure is 66% for the normal insurer and 72% for the Treasury Managed Fund.
That's an improvement.
I think it's stable is the best way we would describe it. The 4-week measure is very volatile,
Yep.
but the actuarial analysis tells us that the last 2 years we've stabilised what we call the front end rates.
Yes.
So they're no longer declining, which is good news from our point of view. But obviously we want to see them starting to move forward. But yes, so I'd characterise them as stable. They're probably up somewhat from 2021 or 2019. Where it was significantly impacted by the issues that existed at that time.
So would you agree that part of the reason that it is stabilising is the introduction of the additional claims model where we have different claims managers?
I'd probably say it's a little early for us to be claiming that victory.
I'd like you to claim it.
We have done, again, some actuarial work that suggests that the experience that we're seeing is in line with the expectations that we had at the time in terms of the financial benefits that would flow through to the scheme. But really, Mr. Tudor, we're less than 12 months through bringing those 6 new providers on.
Yep.
And as you know, the scheme is a long-term scheme. It takes time for the benefits to flow through. So we're comforted that it's stable. And as I said, we've transitioned 200,000 employers away from EML
Yep.
to new providers.
And what's the process that you've adopted for transitioning particular claimants away from a particular provider to?
But so we're transitioning employers rather than claimants, because we don't want to disturb. The whole point is not to disturb the existing claimants, and so that's starting to build up new capacity within each of those new providers. There's more to do. That will continue to run through to June this year, June 24, and at that point we'll have probably reallocated as much as we need to, and then at June 24 we reduce the restrictions on employer choice. So at the moment, only employers with so what we effectively call large employers with premiums over $500,000 are able to choose their claim service provider. Come June this year, we reduced that to $200,000 in premium, so we start to get a whole lot of medium-sized employers in there, and the following year we would consider further reducing that possibly down to $30,000, which really means that all of the medium and large employers have choice, and it really is only small employers who then sit within that sort of allocated pool.
Yep.
And we would allocate that pool based on the performance data that we see coming through the CSP.
And what proportion of claims do you expect would exist across the board in terms of the various providers? Would EML continue to have the vast majority of...
EML will always be our largest single provider just because they have the historical tail of the business.
Yes.
But we would hope, certainly by the end of this calendar year, I'm talking now, so not June but December this year, to have a much more even spread of claims across the new providers, and them to be competing soundly in the marketplace. So EML, I think, I'm just a bit struggling with this year because I'm not sure what we revealed in our RFP to them or not, but I think EML we would expect to still end up in the order of 30% of the scheme, 30 to 40% of the scheme,
Yep.
no matter what we do.
Yep.
Bearing in mind that they started at 88%.
If I can turn to you, Mr. Curtin, the Unions New South Wales and Mark Morrie made very serious criticisms of the McDougall report, and he said this: important elements of Safe Works conduct and operations, in particular ignoring the fact that unions have been consistently unsupported by the regulator when advocating for safe workplaces. What do you say in relation to that allegation?
I think Mark Morrie's made a comment about the review undertaken by Mr. McDougall. The review is now public information. I don't have anything to say about the comment that Mr. Morrie's made about the review.
Do you reject the criticism?
He's making a criticism of the review.
Well, I realise that, but what he is effectively suggesting is that that there are important elements of Safe Works conduct and operations which have not been examined by the review.
The review undertook a comprehensive process of receiving submissions from a range of stakeholders. They met with certain people and received a whole range of documents from different organisations and undertook a comprehensive review over a 12-month period. The government has accepted or endorsed the recommendations of the review, and SafeWork will now be working to implement those recommendations of the review to make sure that we are a strong, robust and fit-for-purpose regulator for work health and safety in New South Wales moving forward.
It may well have been the Auditor-General who's raised this issue, which has now been referred to the ICAC in relation to an air quality monitor called Air XS. When did you first become aware of the issues relating to the procurement of that unit?
I started this role in early October, and I was aware during October of the concerns in relation to that device.
And in respect of those concerns, what steps did you take to deal with it?
Mr. Tudor-Hope, I might just step in for a moment. The issues related to the Auditor-General's report on the procurement of that device are, as is indicated in the report, subject to a referral to ICAC and under consideration by that organisation, and I think it would be appropriate to allow that process to examine all of the issues surrounding the procurement rather than to seek to consider individual elements of it in today's proceedings.
Thank you for that. I'm asking about what Mr. Curtin did in relation to the issue when he became aware of it, not in relation to whether there was any, not in relation to potentially corrupt conduct in respect of the procurement process, what the particular official did in relation to it. What did you do?
In relation to the procurement
Why
of the
didn't
product,
you refer it to ICAC?
It was referred by the Department of Customer Service.
pardon?
It was referred by the Department of Customer Service, and then it was referred by the Audit Office.
You would be aware, excuse me, if I can intervene again, it's an obligation under the ICAC Act for principal officers of an agency, so the head of an agency or the head of a department to refer. The referral occurred during the course of the audit, and the audit report itself notes that both the Auditor-General, this predates me being there, but both the Auditor-General and the department had made referrals to ICAC in line with ICAC's reporting guidelines.
And what I'm trying to get is a timeline in relation to that reporting.
Well, I could, because it was an
Well, I'm
obligation on
happy
the
for you to
principal
give me that
officer, and the
timeline.
principal officer would have been the former secretary of the department. I can look into that.
You can give me a date on which that referral was made?
Well, I haven't. I don't have it in front of me, but I'm sure I will be able to provide that to you. I won't be able to provide the date on which the audit office referred it, but I should be able to establish what date.
So when the audit office, so just so that I'm clear, when the audit office came and were doing their review of Safe Work New South Wales, a referral had already been made, had it?
No, I'm not saying that. I'm saying that the Audit Office report confirms that during the course of the audit, both the Audit Office and the department, and I take that to mean the Secretary, on whom the reporting obligation rested, made the referral during the course of the audit. The audit was largely complete by the time I started.
And my questions, Mr. Head, were these. Was the head of the department already aware of this issue and had not reported it?
Well, I would have to look at the detail of how that worked, and to the extent that I'm able, I'll take that on notice.
Because I just want to be absolute. The timeline is important for this is a significant contract, a significant procurement contract, and in respect of the obligations to report potential issues to ICAC, potentially some procurement issues relating to this may well have been avoided if a report had been made earlier.
Well, if indeed people were aware of the issues. But I would add as a caveat that while I'll take that on notice and look at relevant elements of the timeline, I can't traverse any of the issues that ICAC may be considering in response to the reference to them.
I don't think I'm going to get it much further in relation to this, but perhaps I can turn to something else in relation to one of the regulatory priorities for Safe Work was to reduce the incidence of worker exposure to dangerous substances in the workplace, particularly silica and dangerous chemicals. Can I just, in relation to that, we've made significant progress, Mr. Curtin, have we not, in relation to, and the Chair has quite rightly identified the legislation which has been, the steps which have been taken to stop the use of silica-based stone. Are there any other proposals which are proposed in respect of other substances, like is porcelain or ceramics, or which are not silicon-based? To have them included in the registry of notifiable dust diseases?
The current process is working through the ban of engineered stone from 1 July, any required transition rearrangements, any exemption framework required, and also to enhance the treatment of other products that don't fall into the engineered stone ban, to make sure that sufficient controls are in place for those that are working with the types of stones that have silica in them right across the industry. That includes the wet cutting, ventilation and respiratory protection for all industries in relation to silica.
Well, just let's be clear on that, is engineered stone which has a silicon base and which in fact is the cause of silicosis, in respect of other products like porcelain, ceramics, are there any other proposals to in fact create a similar outlawing procedure in relation to cutting in respect of those products?
The decision regulatory impact statement found the correlation between the engineered stone with high percentages of silica and silicosis, and so the ban that's coming in on 1 July is focused on engineered stone with high concentrations of silica. Other products weren't examined to the same degree in that DRIS. And so there are opportunities, if there was further research or for further connection between other products and silicosis, to review those in time as they naturally would be. In the meantime, we're concentrating our compliance efforts on making sure compliance with good practices in terms of wet cutting, ventilation, respiratory protection, and health monitoring for those in industry, so that they can be sure that they've got the safest possible conditions with those other products that aren't banned.
Do you want to ask any questions in relation to that? No.
No, fine.
So effectively, the regime is in relation to potential impacts on respiratory outcomes, not in respect of a notifiable disease which is connected with the product involved. So I might not be clear on this, but to the extent that Safe Work is implementing a regulatory regime, it is seeking to identify potentially the work environment in which cutting of a product is done and the impact of that cutting on respiratory illness.
Yeah, the creation of the dust.
The creation of the dust.
Yeah.
Yeah. And I suppose the things that you'd be looking for is the extent to which in the work environment people will be using masks and the like in circumstances where they're exposed.
Yes, we'll maintain a comprehensive compliance program for the foreseeable years, making sure the industry is compliant.
But there is no further proposal to be outlawing by regulation any other products in respect of stone cutting in relation to other products.
Yeah, the definition in relation to engineered stone will be finalised and determined by ministers at the March meeting.
So the definition of engineered stone?
Correct.
And have you made a proposal in what engineered stone should be defined as?
That's currently part of the discussions that states and territories in the Commonwealth are having at the moment to finalise the proposal to go to ministers for ministers to make that decision.
Has your department done a proposal which includes a definition?
We've been part of the discussions in the national forum to make sure we have an agreed
What
position.
is what is Safe Works New South Wales' definition of engineered stone?
Well, they're still under discussion with the,
the
states and
Is it
Commonwealths.
not great at is it not that the threshold will be less than 1% of silica by weight?
That's one of the parts of the definition, yes.
Wouldn't that catch other forms of stone as well? If
No.
engineered stone, if that's the threshold for engineered stone, how is it that granite would not be caught, or sandstone, which have, well, ceramics don't have silica and marble doesn't have silica in it, but granite and sandstone is almost pure silica.
Yeah, the policy position from ministers was to seek to ban engineered stone with high contents of silica. So those stones that have less than 1% of silica content aren't intended to be captured by the definition and therefore won't be captured by the ban. The finer details of how that definition will work will be put to the ministers in March.
And that's 1% of silica by weight.
Yeah, by testing of the content of silica in the engineered stone. Yeah.
Euclid. Mr. Head, can I asked some questions of the Minister earlier about her contacting the agency in relation to the employment of DLOs. You would have a clear view in relation to the appropriateness of ministerial interference in respect of DLOs, have you not? Would you not?
I have a clear view of the employer responsibilities of agency heads and the extent to which, in the exercise of those functions, agency heads are or are not subject to the direction of ministers.
And if in fact a minister had made an approach to a department identifying a specific DLO that they wanted employed, in what circumstances would that be outside of her or the minister's ambit, or should I say, would it breach the code of conduct relating to a minister in seeking to engage that DLO?
It's not for me to opine on the ministerial code of conduct, but I understand that when the changes were made to the GSE Act, and you're aware that those changes were made in response to a recommendation that I made to the previous government, I believe that the code and the Act are consistent, and that the point made in both relates to directions by ministers, not it's directions by ministers to department heads or agency heads in respect of employment matters that are prohibited.
Also, a direction to consider a particular person for placement in the minister's office. Would that?
Maybe from a whole of public service perspective, I could help Mr. Tudor. It wouldn't be. Mr. Head's clarifying, if a minister tried to direct a secretary to appoint someone to a particular role, whether it be a DLO or anything else, that would be in contravention. If a minister's office is aware of somebody who they regard as highly capable and they would like that person considered as part of the process of appointment, I don't think there's anything particularly wrong with that, as long as it's done on the basis of that they're doing that because of merit, not because of some other affiliations they may have.
Well then, and thank you for that clarification. But if in fact the relevant public servant felt it necessary to remind the minister of her obligations in relation to the appointments which are being made of DLOs, would you not view that as the public servant taking the view that the intervention by the minister's office was inappropriate?
That's extrapolate. Sorry.
Point of order's been taken.
Just really struggling to understand how, in circumstances where the head of the public service has said that such a thing would not be improper, that it could be relevant to ask an official about an opinion that some other public servant may have formed. What's the relevance of the opinion the other public servant may have formed? I just don't understand how it's relevant when we've got direct evidence from the head of the bureaucracy.
Well, we don't have direct evidence. Have the direct evidence is what I've put to the minister. That's the direct evidence.
Well, we shouldn't be seeking opinions or opinions of other people's opinions. So if you could reframe the question, Mr. Tudor.
Concerns raised by the department about the behaviour of the minister's office in respect of concerns raised by the department would give rise to concern, would it not, in circumstances where they thought it necessary to, in fact, file note their concerns? Would you not see that as an indication that this was not just seeking like an alternative for merit-based appointment, but in fact went beyond that?
I don't want to extrapolate from any particular circumstances, but it's certainly the role of senior public servants, and particularly secretaries, to provide advice to ministers and their officers about those codes and the policy on DLOs. So if a person in a minister's office, I'm speaking generally here, if someone approached a department and was asking about a particular person, I think it would be quite appropriate for the department to go back and provide advice about what was and wasn't appropriate, without the fact that them offering that advice being an indication of anything untoward have happened.
Well, the facts may speak for themselves. Mr. Head, I think you may have answered this earlier, but you will supply me on notice the exact date on which DCS actually referred the air excess matter to the ICAC.
I said I would take that on notice.
Yes, thank you. Do you know when the Minister was advised in relation to the referral?
I'll take that on notice also.
Yeah. There are a number of recommendations made by the Auditor General into the effectiveness of safe work. How do you see your role in relation to responding to the recommendations? This is not just to the department, this is for you, Mr. Curtin, and some which would apply to the department as a whole, not just Safe Work New South Wales. So what's the process for dealing with the Auditor General's recommendations and the implementation of those recommendations, both by Safe Work and by the department?
The Secretary of the Department is Safe Work according to the Work Health and Safety Act. So the recommendation, until such time as Safe Work is a standalone entity, I'm responsible for implementing those recommendations. Just excuse me for a minute.
Is work being done currently for the purposes of progressing legislation in relation to establishing Safe Work as a standalone entity?
As the Minister indicated this morning, and I can't recall whose question it was in response to, work is already underway to look at how to give effect to the recommendation around a standalone regulator, and Mr. Curtin and I are working on that in order to look at, what are the relevant features for Safe Work and what the options are to respond to that recommendation.
So there will be a model similar to, I think, the Environmental Protection Authority, which will be set up for the purposes of...
That was Mr. McDougall's recommendation, and as I've just said, where Mr. Curtin and I are working together to provide the government with advice on those things that are relevant to Safe Work's creation as a standalone regulator.
Is it too early to ask whether Treasury is involved in relation to that modelling?
Well, at the moment I'm working with Mr. Curtin. There are always discussions across government, because ultimately the government will need to consider the advice. Treasury will advise in that process, and of course Safe Work is funded differently. It's not funded out of its operations aren't funded out of the consolidated funds.
Can I ask you this, Mr. Head, in terms of the working model going forward for Safe Work, what do you see as potentially the oversight model for Safe Work as part of that standalone entity?
Well, the Minister made some references to oversight in her comments this morning. I don't have anything specific to add to that at this stage, where the report was released only very recently. The Auditor General's report came down this week. There's quite a lot of work to go through comprehensively but quickly to work out the detailed options here.
Thank you, Mr. Head. Thank you. We will now break. Do you have more questions after the break?
No.
You don't?
No.
All right, well, then...
But if we can have a break so we can all have afternoon tea. I'll come back and ask one question, then we can...
Oh, I think we can have afternoon tea as well. So, in the absence of any further questions, that will conclude today's hearing. But so thank you very much all for your attendance and your evidence. We just need to have a quick deliberative here, very quietly.
Thank you very much, everybody.
Thank you.
Thank you very much. And the Secretariat will be in contact with any regarding any questions taken on notice. We didn't have any... Okay, so was it nothing? Okay, we didn't have any tendered documents.